Good morning, everyone. Benali, can you please confirm whether you can hear me?
Good morning, Gift. Yes, I can hear you.
Yeah, good morning, everyone. My name is Gift Monzora. I'm a postdoc fellow under the South African Research Chair in Cities, Law and Environmental Sustainability. I welcome you all to this virtual colloquium on local government autonomy, focusing on Zimbabwe and South Africa. The topic is quite timely and relevant in both contexts, considering the heavy involvement of central government in the running of affairs of local government, especially urban municipalities. So the question in the offing is, where is the dividing line? Where does the central government ends in terms of its involvement in the administration of local government? We thought it would be interesting to draw upon case studies from two countries with varying constitutional traditions and varied political context also, and again, varied levels of constitutionalism. So we thus seek to pass out whether there are similarities or differences in terms of patterns of local government, how it's guaranteed in terms of practice and in theory. Inter alia, we seek to analyze whether local government autonomy can promote good governance, the good governance agenda, and whether local government autonomy can also promote service delivery, and also, among other issues, can promote devolution. Without taking much time, I now introduce you to the South African Research Chair in Cities, Law and Environmental Sustainability, who can speak briefly about the center and also about the program. We are also very grateful that you managed to be part of our discussion today in what looks to be an interesting discussion. So, Prof. Anil du Plessis, over to you.
Thank you very much, Gift, and good morning, colleagues. Also from my side, on behalf of the South African Research Chair in Cities, Law and Environmental Sustainability, I would like to welcome you to this colloquium that focuses on a very important aspect of constitutional law, but definitely also of the protection of democracy in South Africa and Zimbabwe. So our work at the chair is very much focused on urbanization and the pressures on local government and cities that emanate from urbanization, but certainly also from governance that is failing at different levels, and the concomitant impacts that have on the delivery on people's needs and reasonable expectations. So it's for this reason that I'm especially grateful that we've got such a lovely lineup of experts this morning. They will be presenting on their views. Some will have PowerPoints, others will not. And while we have a very strong male presence, I should add, some of you might have seen that, I can report that we have a predominant number of female participants today, and I am sure that we will be able to even out in the discussions. To ease us into the program this morning, I would like to say that for me, local government autonomy, in short, translates into the freedom to govern. And this freedom to govern is being impacted by several things, including, but certainly not limited to, politics that dictates decisions and policy in many instances, financial independence of municipalities or then the lack thereof, failure on the part of municipalities to take up the self-government space, if we can call it that, misinterpretations of the principle of subsidiarity, understanding what should best be governed at which level of government, and the idea that the constitutional protection of local government autonomy is sufficient to protect and ensure the freedom of municipalities to govern in real life. So my hope is that our deliberations today will focus on the two sides of local government autonomy in South Africa and Zimbabwe. The first being its continued and perhaps increasing relevance for democracy and sustainability. And then on the other hand, the responsibility on the side of local government or municipalities to responsibly claim and constructively employ its autonomy to the benefit of all local communities. I would like to thank Dr. Gift Mwanzora, who has initiated and organized today's event with the help of Bernally Anthony. And perhaps before we proceed, I should be saying that we've got a few possible challenges this morning. Many of our presenters are based in other countries, most in other African countries. Internet connectivity might be a challenge, and I would therefore like to ask that everybody keep their mics muted and their cameras off when not presenting. And we will be muting those who have mics open for the sake of those that would like to listen in. And then perhaps also to mention that we might have to move around with the program if someone drops from the call, that's a presenter. And we just like to ask that you bear with us. So the first facilitator then is Gift Mwanzora. Gift, I'm going to hand over to you shortly. If you can just in the meantime check that our first presenter is in the list of participants and able to proceed. Otherwise, we will have to start with either Prof. Chigwata from the University of the Western Cape or Honorable Brian Dube, who I know is present already. And then in the first half of the program, I can perhaps mention that we have the Zimbabwean perspective. And after the comfort break, round about 12, we will proceed with our deliberations on the South African side of things. So, Gift, can you confirm that our first presenter is available? That is Dr. Gordon Moyo.
Yeah, many thanks, Prof. Your time is up, unfortunately. But all the same, many thanks for the welcome remarks. So, Dr. Moyo has not yet joined us, so we'll move to Professor Tinashe Chigwata from Dula Oma Institute of the University of Western Cape. So what we'll do, we'll start with the Zim session, then afterwards we'll go to the South African session. So Professor Tinashe Chigwata, we invite you to speak to the audience.
Thank you. Thank you, Gift. Am I audible?
Yeah, I can hear you.
Okay, all right. Thank you. And thank you for the invitation. And I'm happy to see a couple of familiar faces in the list of participants. So it's always good to see some old faces. I've been given the task to say something relating to the subject of local autonomy, both at law and in practice when it comes to the local government system in Zimbabwe. My presentation will cover a few issues. I'll briefly try to define local autonomy, and Prof. Anil has already spoken a little bit about the values of local autonomy. I'll also look at the level of local autonomy in the 2013 Constitution before giving you my views on local autonomy in Zimbabwe, both at law and in practice. And I will end my presentation with a few remarks regarding the status quo of local autonomy in Zimbabwe. Just on the way I see local autonomy, I think Prof. Anil has already tried to define that. For me, I think local autonomy just entails the extent to which local governments have discretion when carrying out their duties and obligations. It, however, cannot be equated to independence. local governments are merely given a certain discretion to make laws, adopt policies, take decisions within a framework of national and regional laws and subject to national and regional supervision, depending on whether it's a two-tier system of government or three-tier system of government. There are basic features of local autonomy. It's not really a settled subject on what are these basic features, but a perusal of international literature and practice, you can pick up a few of them. And what I could pick is that, on local autonomy, the first important part of it is the security of existence of local governments. So there needs to be a certain measure to guarantee the existence of municipalities or local authorities. The second aspects relate to the nature of functions that local government is responsible for carrying out, and the nature of discretion that municipalities or local authorities have when carrying out those functions. Another critical aspect of local autonomy relates to local democracy. In other words, how democratic the local institutions are. And the critical part of also local autonomy relates to the resources and the discretion which municipalities or local authorities have to spend those resources. And also the discretion to appoint staff, to establish local bureaucracies. That's another critical part of it. And lastly, the extent at which high levels of government can interfere in the exercise of local powers. So these are more or less some of the basic features that if you peruse international literature, you can come across on local autonomy. The value of local autonomy, I would say, I would get into detail too much, just to say that there are a couple of theories that speaks to the values of local autonomy, including the democratic participation theory, which speaks to about that local government is there to enhance democracy. You've got the efficiency services theory as well. You've got other theories like the localist theory that essentially say that the communities know what is best for them. So they require a certain measure of autonomy to be able to determine what is best for the environment. There is what I refer to an enabling environment for the realization of local autonomy in practice. What are some of the key features do you need to fully realize local autonomy in practice? I think the first part of it is that local autonomy must be entrenched. So you cannot talk about the realization of local autonomy in practice if it is not entrenched, either in law or in the constitution. So you need an appropriate framework for local government. The crucial aspects of decentralization or devolution must be adequately entrenched and balanced. So that's the first thing. If it is not entrenched, then I think it becomes difficult to go on to other points of inquiry. The first thing is it must be entrenched. Once it is entrenched, the second crucial aspect is that it must be implemented. So the local government framework must be implemented well. So in other words, you need appropriate laws, policies, and resources must be given to local government. Appropriate institutions must be established. And importantly, you need a culture of tolerance. So as a national government, you should be able to tolerate a subnational unit or a municipality or local authority that is controlled by an opposition. A third dimension is that local governments need to have the capacity as well as the will to exercise local autonomy. We have seen a number of countries where local autonomy is well entrenched in the constitution, but there is no capacity or the will to exercise that local autonomy. There must be that appetite to exercise local autonomy. Then lastly, I think a culture of rule of law and constitutionalism is important. You need respect of the law and courts, and you need an independent and effective judiciary for you to realize local autonomy in practice. Because the constitution can say local government have the autonomy to carry out a number of things, but if the constitution is not respected, then you won't realize the values of local autonomy in practice. So a culture of rule of law and constitutionalism is very important for the realization of local autonomy in practice. What is the level of local autonomy in the 2013 Constitution of Zimbabwe? I will now turn on to the Zimbabwean Constitution. And one of the critical questions there is that is local autonomy in this real or is it imagined? Is there real local autonomy in the Zimbabwean Constitution? If you look at the Constitution, I think you can see there are quite a number of positive, attributes as far as decentralization or devolution is concerned. For instance, devolution and decentralization are some of the founding values and principles of the Constitution. If you look at your chapter 14 of the Constitution of Zimbabwe, there is, in the preamble, there is an instruction that, the need for devolution of power to realize a couple of objectives linked to development, service delivery, and national unity. Local authorities are equipped with the right to govern in terms of Section 276. For the first time, intergovernmental grants are entrenched or provided for in the Constitution with the requirement that at least 5% of national raised revenue must be given to local authorities and provincial councils and metropolitan councils in each financial year. There's also a certain measure of protection of councillors against arbitrary removal, something that was very common under the old constitutional order. But if you examine the entire Constitution as a whole, particularly chapter 14, which relates to local government and in this case, local autonomy, you will see that a key feature of this Constitution is that most aspects of local government are left to the determination of Parliament through laws. So Parliament has been given a very active role to operationalize the devolution framework that is provided in the Constitution. So in my view, local autonomy in this case has been left to the whims of party politics. In other words, the political makeup of Parliament and the direction which Parliament takes determines the course of devolution and local autonomy in particular. And this means that without a pro-decentralization executive, a pro-decentralization or devolution Parliament, and a pro-decentralization or devolution judiciary, you are likely to witness marginal or minor movements on the devolution front or on the local autonomy front. So those are my views when it comes to, in brief, when it comes to the level of local autonomy in the 2013 Constitution. Now, I will now turn on to the issue of local autonomy in practice. The first question is the local government framework appropriate? In my view, the constitutional framework for local government is sound, but it is not adequate. So if you look at it, if you examine closely, it is sound enough to establish an effective system of local government, but it is not adequate in other areas. What about implementation? So the implementation of the constitutional framework for local government has been very slow and painful. An example is that despite the constitution has been adopted in 2013, which means 8 years ago, there are still no the enabling acts to put in place the constitutional framework for local government. The 2016 amendments to the Local Government Act dealing with the discipline of councillors, while noble in trying to fill the vacuum, in my view, I think they are a detriment to local autonomy in that they provide for a significant role of the minister in the suspension of councillors, something which the 2013 Constitution, I think, attempted to do away with. Devolution funds, we've seen them now being disbursed, is something positive, but the question is whether their disbursement meet the constitutional master. Because the Constitution says there must be equitable sharing of revenue, which means sharing of revenue relative to responsibilities. So if you look at national government, if you look at local government, who is responsible for what responsibilities, the revenue sharing model must then follow that. So the minimum of 5% provided in the Constitution is only the benchmark. In other words, more funds should be actually be allocated to local government. But if you look at what has happened over the past 2 years, you would see that the amount of money that was allocated doesn't even meet the 5%. Is not even 5% of national raised revenue. The second challenge is that the money is not dispersed to local authorities on time. So there is the announcement that we're going to give you devolution funds, but in practice, the actual disbursement takes a while and usually happens in the later part of the year. Then there are several, I think, issues that have been happening in practice that points to some form of re-centralization, parallel form of re-centralization that is taking place. So whilst the constitution says you need to decentralize, you can see on the other hand that there are certain acts that the national government is doing that may point to some form of centralization. And this relates to, for instance, the way in which the parastatal responsible for road administration disperses funds to local authorities, giving them insufficient funds. The role of the recently changed officials that have been changed their names, district and provincial coordinators, in their relationship with local authorities. What does that point towards? Devolution or some form of significant deconcentration? So the implication is that all of these, acts that has been happening points to some form of parallel re-centralization that is taking place, yet the constitution says you must devolve. If you look at other critical aspects of local autonomy that I say that for it to be realized in practice, you need a culture of tolerance. The critical issue is, does the ruling party tolerate an opposition governing a local authority or a municipality in Zimbabwe? That's the major question. If the ruling party cannot tolerate an opposition at the subnational level, then you won't realize local autonomy in practice, because that is the value of local government. For you to have an effective system of local government, you need a ruling party that says, I am the ruling party, but I'm giving you the freedom to govern at the local level, and I'm willing to work with you for the betterment of the community. If that toleration is not there, then it is difficult to establish an effective system of local government. Then the question of rule of law and constitutionalism, I think that's another one that is very important. If the constitution says, Chapter 14 should have been implemented soon after its adoption, why take 8 years to operationalize it? The perception around the independence of the judiciary and their effectiveness when deciding cases, all of those factors, I think, reduce the appetite for stakeholders in local government to use the courts to advance local autonomy. My last slide, the status quo. So as a result of a number of challenges, whilst the constitutional framework on local government is sound, but its implementation, as I said, has been, I think, painful and very, very, very slow. There are positive, I think, things that can be pointed out that are happening in practice. For example, the devolution issues, devolution funds, even though in my view, their disbursement thus far has not met the constitutional master. What you see in practice is that there are significant service delivery challenges. There are also significant capacity challenges. Local authorities, because of the absence of local autonomy, they are experiencing a lot of challenges in delivering services. At the end of the day, you have an uncountable and unresponsive local institutions, which are characterized by, among other things, ineffectiveness, corruption, among other ills. And you also see that citizens feel alienated from governance processes. And the reasons, in my view, are that the local government or legislative framework is inadequate. In other words, the constitution has not been properly implemented. Whilst it has got its own weaknesses, the local government, the absence of enabling laws, I think, have made it difficult for local authorities to even realize the marginal gains brought by the 2013 constitution. The political and economic environment as well in Zimbabwe, I think it's posing a huge challenge for the realization of local autonomy in practice. And in my view, and this is my last sentence, is that I think at the moment, local autonomy in Zimbabwe is more imagined than real in practice. Thank you.
Many thanks, Prof. Chigwata, for that sound presentation. I think you raised many vital points that will generate discussion. At this point, I now invite Honorable Brian Dube to present. Over to you, Honorable Brian Dube.
Thank you very much, Gift. You hear me?
Yes, I can hear you. Kindly go ahead.
All right. I'll ask the person that you assigned to share the slide. Thank you. Maybe we can quickly get to slide number 3. Ale? Right, yeah. That's where I want to start the discussion on. This presentation is an examination of the Zimbabwean local government autonomy law or system in law and in practice. The presentation highlights how both the law and the practice undermines the autonomy of local government structures in Zimbabwe. It will further highlight why the law on local government is not democratic and qualifies to be called a draconian law. Then it will end by making recommendations. So maybe we can go to the next slide. Thank you. Like indicated by Prof already, the local government framework in Zimbabwe is in Chapter 14 of the Constitution of Zimbabwe, which speaks to devolution of power and responsibilities of lower tiers of government in Zimbabwe. The objectives of devolution of power and responsibilities have also been highlighted, but I will hasten to also add that it gives power to local government to the people and enhances their participation in decisions that affect them. To me, this is more important, that decisions that affect people must also be done with their direct involvement. It promotes democratic, effective, transparent, accountable, and coherent government. It preserves and fosters peace, national unity, and indivisibility of Zimbabwe. It also recognizes the right of communities to engage to manage their own affairs and further their development. It also transfers responsibilities and resources and ensures equitable sharing of local and national resources. That's how I understand the importance and the value of the framework on devolution that establishes local authorities. We may go to the next slide. Thank you. The Constitution of Zimbabwe, in its Chapter 14, establishes provincial and local government structures. Section 274 and 275 of the Constitution provides for the establishment of urban and rural local authorities, respectively, and their functions are as summarized from those two sections: to represent and manage the affairs of the people in the localities, to govern local affairs, to make bylaws, regulations, and rules for effective administration of their areas, and to levy rates and taxes for purposes of providing service delivery. And they are the custodians of land and resources at local level. Basically, that's what the Constitution empowers these local authorities to be doing. We go to the next slide. From this slide, I have summarized the two separate laws, which is the Urban Councils Act and Rural District Councils Act, for purposes of time, because the effects and consequences are the same. So, in short, what I am saying about the Urban Councils and Rural District Councils Act, the two laws are, in my view, an erosion of the established or the envisaged local authority autonomies in terms of the Constitution. in the sense that the minister has powers to suspend councillors on reasonable grounds and do investigations later within 45 days. And this has been abused in the previous constitutional framework before 2013, and again it's still being abused now. I can tell you that, for example, after the 2002 elections, where MDC had the mayor for Harare form of engineer Mzuri, the government used these powers, the Minister of Local Government used these powers to suspend him, and actually until the end of his term he was out of office, and they to put someone that they wanted. So it is an erosion of the rights. And I can also give you an example in the new constitutional framework, where in 2016, using this law in the Urban Councils Act, the Minister of Local Government wrongfully suspended the members of council, or the councillors for Gweru Town Council, all of them, the 18 of them, on frivolous charges, and they won 2 times at court, and the decisions were not being implemented. But the idea was simply to make sure that they were not there because government wanted to implement some programs that they wanted the exclusion of the elected councillors, which is actually now part of the problems that we are facing relating to the illegal acquisition of lands around the Gweru, which has resulted in the arrest of the former resident minister, who is actually now serving a jail sentence. So it is very problematic. The minister has also powers to approve and reject budget proposals by local authorities. This is very problematic in the sense that it has also been used irrationally, where local authorities have had serious disruptions of service delivery because the minister, one, it takes too long to even approve the budgets, and because of the hyperinflationary environment, by the time the budgets are approved, the figures will no longer be able to tally with the service deliveries that are required, and in the end the local authorities will be viewed as incompetent or unable to discharge of their duties, and the same government which would have crippled that through a delayed budget process will start to blackmail the authorities for failure to perform. Councils have no power in terms of the Urban Councils Act and the Rural District Councils Act to appoint senior members of staff such as the town clerk, chamber secretaries and directors, as they require the approval of the local government board, which is actually appointed by the minister. The problems with this is it has been used to establish a parallel system in the local government structures, because the local government minister has made sure that a majority of the town clerks and directors are aligned to his party, and they work contrary to the resolutions and the interests of council. And this has actually crippled the operations of councils. I can confirm that as a result of this problem of the local government board, we have also had a number of acting persons in senior management positions in the local government, because the local government board was not there for a while, and the minister just appointed it recently. So for over a year, they have not been able to employ permanently senior management in local authorities, which also seriously affects the performance of duties in the local authorities. Councils also cannot fire employees without the approval of the local government board, and this has caused councils to stick around with the incompetent, corrupt and insubordinate senior management in local authorities, because they have no power to actually dismiss them without the involvement of the minister indirectly through the local government board. Though the local government board is appointed by the minister and not subjected to any public interface or any known system of how someone qualifies, and this also defeats the purpose of transparency and accountability. Practically, a majority of urban local authorities have councillors and mayors from the opposition, and the minister deliberately influences employment of ruling party affiliated senior management suspected to be sabotaging local authority operations. Delay in appointment of the local government is also, like I indicated, resulted in the crippling of the functions of the urban councils in Zimbabwe. We can go to the next slide. There is also a challenge which arises from this office, which is called the Minister of Provincial Affairs and Devolution, which was previously also referred as to the Resident Minister of State, and at times also referred to as the Provincial Governor. This office is established through an unknown law, because there is no law that explains how these people are supposed to be there. So they are appointed by the president for each of the 10 provinces. They regularly summon and call mayors, councillors, and senior council employees and give them irregular instructions. And this has been given as an example already, where I indicated to you that in Midlands we actually have had problems relating to illegal allocations of land, and actually land barons and land looters connected to the former resident minister actually using this office to do these things. So there is also inappropriate settlements which have been done on wetlands and unapproved layout plans, disrupting town planning. So as you go around the cities in Zimbabwe, you realize that town planning has seriously been disrupted, as a lot of illegal structures are being established where land is sold irregularly and developments are done where, like what we then experienced in Gweru when the floods came. We had a crisis of over 700 families now suffering because they were given land to build along the Gweru River, which then flooded, and they had their wells washed away and their homes inhabitable, and this gave a serious crisis to the city. There is also an issue of this office actually claiming 10% commonage for all developments done and around the local authorities. This has also resulted in serious loss of revenue from local authorities, as well as just increasing the levels of corruption in Zimbabwe. So this office, as far as I'm concerned, is one of the main attributes towards the erosion of the autonomy of the local authorities, as an undefined office is affecting how the local authorities are functioning really. Let's go to the next slide, which is my last slide in respect of this presentation. We need to align the local government laws with the Constitution. The Constitution is very clear on the functions of local authorities, but the Urban Councils Act and the Rural District Councils Act is not in conformity with the Constitution, but is being implemented, which is very problematic. We also need to reduce the powers of the minister in local government. The powers of the minister in local government are so wide, and they are too powerful to an extent that they can disrupt the operations completely. This is also observed actually currently, where we have devolution funds which are being disbursed where there is no provincial structure that has been sworn in, there is no secretariat in the provincial structure, and the minister is actually distributing funds through local, urban or rural councils and giving them specific projects to implement, wherein you then find in the whole country people are now being forced to go and buy certain graders from a single company, and it's not following the plans and priorities of councils in terms of what they really want, as the minister will tell them that this devolution fund must be used solely for this purpose. We need local authorities to have power to employ and fire senior management on the basis of the law, like any other institution that employs. The labor laws must apply, not this aspect of actually having the local government board interfering with the relationship of an employer and employee, because councils are the employers and the council senior management are employees, and they must just be regulated through the Labor Act and not this process which is politicized and which is the very unclear onto the purpose and function. We also need the Minister of Provincial Affairs to be formally abolished, because it serves no purpose, as it is just there to disrupt the smooth operations of local authorities. We need local authorities also to have autonomy to procure subject to standard procedures and tenders. The procurement authority of Zimbabwe takes too long and disrupts local operations and defeats the easy way of doing business, really, because you need to seek approval from them and they are inefficient in the way that they function. So basically, this is my view relating to the Zimbabwean perspective, as I understand it, in as far as local autonomy is concerned. Thank you very much.
Many thanks, Honorable Brian Dube. So, Honorable Brian Dube is the Member of Parliament for the MDCT in Gweru Urban constituency, if I'm not mistaken.
Yes, yes.
He's also a lawyer. So, in the interest of time, we are having connectivity challenges with some of our presenters. So I just wanted to pose a question to you, Honorable Dube. Do you think the major challenge in terms of local governance autonomy in Zimbabwe is the disparity between the Constitution of Zimbabwe and the local government laws? Is there a need for alignment? And also, if there is need for alignment of local government laws with the Constitution, how about the aspect of adherence to the local government laws? Now we are speaking about constitutionalism.
Yeah, my first point from a legal perspective is that the alignment of the law is very important, because it will also then give limitations, because the law must then, if it is aligned, the powers will be reduced of the minister, who is actually disrupting the operations of the local government systems. Then on the issues of adherence, we also then need to have reforms in terms of the political orientation, where people must then understand the separation of issues, where if we are talking about development and service delivery, it must not be confused with the issues of people wanting to score the political goals. But I believe that the powers that are in the Urban Councils Act, if they are reduced through alignment of the Constitution and the Act, they will go a long way in even reducing the level of interference, and it will make it easier for litigation. For example, I will tell you, when we litigated to have our councillors restored back to their position from 2016 to 2017 in Gweru, we faced serious challenges. It was fortunate that the High Court was actually proactive, because we are actually explaining about the procedure of the removal of a councillor from their office in terms of the Constitution. And the Ministry of Local Government came, and their opposing papers were actually speaking to the powers in their Urban Councils Act and saying it is the law that is there because it has not been amended. Do you see the challenge that we are facing? So it was prudent and fortunate that the judge had to actually indicate that it does not matter that you have not caused your act to be amended. We will stick to what the Constitution says and not what that Urban Councils Act says. But if we were not sharp to insist on the constitutional framework and also citing the constitutional law cases that cemented that position, another lawyer appearing before a different judge would have had a difficult time. For example, I will tell you, I think in the same time that we were fighting our Gweru case, the Chitungwiza one was also ongoing, and they were facing serious challenges. And actually, I think the lawyer had to contact us to find out how we had done it, and yet to redo his process there, because he had actually relied also much on the Urban Councils Act and not the Constitution. So what I can say, Dr. Monzora, is that it is very important that we align the laws.
Yeah, many thanks for quite substantive elaboration. I think I also have another follow-up question. In terms of local government challenges in Zimbabwe, is Parliament well equipped to address all these issues? Do Parliament grapple with some of these challenges, especially in terms of human settlements in wetlands? We are looking here perhaps at the Parliamentary Portfolio Committee on Local Government. If you can speak to that.
On paper, yes, the Parliament through the Portfolio Committee has powers to actually deal with these issues, but in terms of just observing issues and making reports, but the aspects of implementation and enforcement of things, they rest squarely with the minister. So what Parliament can only do is to make recommendations and recommendations. But the trend and tendency of the executive has always been not to implement those recommendations as highlighted. And our major challenge becomes the issue of how to then enforce that, because you also realize that, for example, you have a parliament where we are also under the majority of the ruling party, ZANU-PF, where the minister of that local government comes from. And that minister of local government is senior to the parliamentary leadership. For example, he's the deputy secretary for administration in ZANU-PF. I think it's a position which is very, very, very senior. And the members of parliament who are supposed to be going to challenge him and tell him what to do will be members of parliament, and they are in the districts, and possibly even if they are in the Politburo Central Committee, very junior to him, and they are afraid to then confront the system. So I can, in short, say it is a nightmare. The local governance system in Zimbabwe is just the stuff and substance that nightmares are made of. Hello?
Gift, are you present?
Okay, many thanks, Honorable Dube. Many thanks, Honorable Dube. I think you can now kindly switch off your video.
Thank you.
Okay, thank you. So we now go to Professor Tinashe Chigwata, who is a professor at Dula Oma Institute at the University of Western Cape. I think, Professor Chigwata, there are some questions that have been posed by the audience here. The first question comes from Chantel Moyo. Chantel says, I would like to ask about powers of oversight of the provincial and national government in instances where local municipalities are actually failing to carry out their mandate. How do we draw the line between exercising oversight and encroaching, or as I have heard in the presentations, interfering in local government autonomy? Can you kindly speak to this aspect?
Thanks, Gift. I was actually typing a response in the chat box to Chantel on that question. In my view, and also based on experience in other countries, you look at South Africa, Kenya, and others, not to say that their local government systems are perfect. I think intervention powers or supervision powers, oversight powers, they are very important. You cannot have an effective system of local government without them. You will need them. But the important point when it comes to, or principle when it comes to those powers, is that they must be regulated and limited. So you cannot have a national government or national minister that just goes on to municipalities and do as they wish. So they need to be regulated and limited. So in circumstances upon which the national government can exercise those powers must be clearly stipulated in law in unambiguous terms. Now, when it comes to a very important aspect of supervision powers, which is intervention. So when a national minister goes to a local authority and say, I'm intervening in this local authority or municipality because of service delivery failures, I think evidence from other countries and experience from other countries suggests that you actually need to provide, the circumstances upon which that minister or the national government can intervene in a municipality to say, if this and this happens, then the minister must intervene. And you must also stipulate how long that intervention is going to take place. And lastly, and perhaps most importantly, is that intervention in a municipality must be subjected to oversight mechanisms. So in cases where a national government or national minister dismiss councillors or suspend councillors, you want that decision to be ratified by Parliament. You want Parliament to be able to say, no, this intervention or this suspension is not in line with the law. It's more politically oriented than legal. So you want those oversight mechanisms to be in place. But in the Zimbabwean case, you will see that the minister can intervene in a municipality, and that specific decision is not subjected to oversight by any other person except by the courts. So the person can challenge the decision only in court. But in other countries, you had, in addition to the courts, other several mechanisms that are there to ensure that arbitrary usage of intervention powers is limited. So there are genuine cases, for example, in the Zimbabwean case, where intervention is required. But the question is, are the intervention powers proportional? The problem is confined to a particular department relating to firefighting services, for instance, but the minister goes on and dismisses all other councillors or targets all other departments in a municipality that has got nothing to do with fire services. The minister intervenes in a municipality, instead of intervening for a 3 to 2 month period, end up intervening for a couple of years. So in that case, now you are suffocating local democracy, because people would have made the choice to say, these are the leaders that we've elected. We want them to decide our local priorities. And the national government comes and say, we are going to do away with the leaders that you've elected and determine a local government from Harare, which is the capital city. So that defeats the whole purpose behind establishing a local government system. In fact, it becomes a local administration. So what you have is local administration because the democratic content is missing. Okay,
sorry, Prof Chigwata, I have to cut you short. I think we had been waiting for another presenter, and he's now, I'm informed, is now available. So we have to move on to another presentation. Thank you for quite detailed elaboration. So we now turn to Dr. Devolution Mchadenyika. Dr. Devolution Mchadenyika is a Zimbabwean urban scholar working at the World Bank, and he is also quite a prolific scholar working on local government. Dr. Mchadenyika, are you ready?
Yes, Gift.
Yeah, over to you.
Okay, thanks, Gift, and other colleagues that have presented before me, and also thanks to everyone who is participating in this workshop. So perhaps before I start, I will particularly focus on local governments in the form of local authorities to try to assess in terms of whether they have some form of autonomy or not. So in terms of my presentation, I will particularly focus on two things. One, I will give a brief in terms of what the local government system is, what are the key elements of the local government system. And secondly, I will focus on 7 areas that actually make the core of the local government. These areas will help us to assess whether there is some form of autonomy or not. The 7 areas are spatial planning, land alienation and management, decision making, human resources, finance, revenues, and budgeting. Having said that, let me quickly just give a context. Perhaps this has been actually been discussed before. That in terms of local authorities, we have 92. The number might vary now if there has been some that has been created recently, 60 being rural and 32 being urban. The principal acts that govern the operations of these local authorities are actually the Urban Councils Act that deals with urban local authorities, and the Rural District Councils Act that deals with the rural district councils. And also the Regional Town and Country Planning Act, which is the principal law that governs the planning and development of urban and rural areas. And lastly, we do have the Constitution that provides for the first time in the post-independence era, that provides for devolution of local government. Before we begin to look at the assessment of autonomy, it is important, I think, as highlighted by Tinache, that autonomy comes with it responsibility and obligations, and therefore any local government should be able to operate within the confines of the law. That's very important to take note of. Secondly, it is also important to take note of that local governments existing in a context whereby there are other levels of government, and in this case, provincial and national government, which I think Tinashe has spoken to already. So there is also need for intergovernmental coordination and cooperation between various tiers of government. Let's move on quickly, I think, to go to the 7 areas that I think can help us to assess the operational autonomy of the local government. One being spatial planning. All urban local authorities, as defined in the Town and Country Planning Act, have full spatial planning powers, except local boards. So there is a hierarchy in terms of urban local authorities. At the apex, we have cities, we have municipalities, we have towns. Those have full spatial planning power. And then below, we have what are called local boards. These are the list in terms of the hierarchy of urban local authorities. So the first 3, they do have full planning powers. They can perform master and local planning. By master, we say this is the long-term spatial plan that gives the vision of the development of the city. And then local plans, they give you planning proposals that guides the development of a certain specific area. But local boards do not have these powers. So the functions of planning are actually in local boards, for instance, Epworth, Wange Local Board, and amongst others, Kirun Local Board. They are performed by the Spatial Planning Authority at the national government level, which is called the Department of Physical Planning. The same applies to all rural local authorities. They don't have forward planning powers. They can't prepare master plans. They can't perform subdivisions and consolidations. So this function is then performed by a national government entity. So their autonomy in terms of forward planning is limited. Again, let me also mention that even in urban local authorities, there is what is called a layout plan that is prepared. But every layout plan that is in excess of 4 or 5 stands or plots is subject to approval at the Department of Physical Planning. So what does this mean? This means that as a local authority, you cannot prepare and develop a new area that is 5, 6, or 10, or 1,000 new properties without seeking approval from the Department of Physical Planning. This helps because the Department of Physical Planning is the custodian in terms of spatial planning in the country. So its mandate is to make sure that the town planning objectives, they are adhered to the letter and spirit. Lastly, on spatial planning, we see whether rural or urban, we see that all local authorities, they have the power to perform what are called development control functions, regardless of size. By development control, we say they can issue out building permits. They can inspect buildings. They can make sure that they control where a certain form of development or a building can be put or not. Let's look at the second aspect, which also helps us in the assessment, which is land alienation and management. Any local government, land is actually very critical for the management and development of any local government. It is also something that helps in as far as the revenue is concerned in any local government. However, when we look at it very clearly, we see that in urban local authorities, they have the powers to alienate, plan and allocate only council land in urban areas. There are three different types of land in urban areas. One is council land. Secondly is called urban state land, which is alienated by the urban state land office in the Ministry of Local Government. So the planning and development in any urban area is spearheaded by the urban local authorities on council land and private land. Also to say that if any urban local government wants to expand, the responsibility to actually carry out any boundary expansion is vested in the president of the country. That is why for the state of Harare, the last boundary change took place in 1996. Where by then, I think the president, through a proclamation, incorporated about 36 new farms around Harare. The challenge then becomes on rural local authorities, many of them which are actually surrounded by communal land. And this communal land is also presided over by the president. So for a rural district council to then alienate and propose or conduct any development of such land, it requires presidential and ministerial consent. The third aspect that I will deal with is to do with the revenues, to try to see again whether there is some form of autonomy or not. But on this question of whether it is an autonomous form of government or not, I will not be able to answer that. I will just give you the data and evidence in as far as the 7 areas is concerned. Zimbabwe is quite unique in as far as the local government revenues are concerned. If we look by African standards, what do I mean? Our local governments in Zimbabwe, they have widespread revenue-raising functions. Let me let me qualify that in a second. For instance, if you look at FYE 2018, the share of local government own sources of revenues, the revenues that they generate to the total revenues that they manage to raise is actually 82.53%. Which means that transfers from the national government were something like 17%. This is quite opposite in many African countries. For instance, let's look at East Africa. In Kenya, 80% of local sub-national government revenue comes from the national government. 10% comes from development partners, and then 10% is on-source revenues. If you look at West Africa, again, this is completely an opposite situation, whereby 90% comes from national government as transfers, and then 10% is on-source revenues. So it is important to note that the success in terms of the financial health of local authorities in Zimbabwe is largely because of the revenues that they generate on their own, and not some form of money that they get from someone else. For instance, if you look at the data again, we realize that between 2012 and 2018, the city of Harare, the largest local government in Zimbabwe, it generated 95% of its own revenues from own sources. Why is this important? From an operational autonomy point of view, if you get money from other tier of government, such kinds of money, they always come with some form of conditions to say you need to use these resources for this or that. It is important at this point to keep in mind again that The 5% that comes from the national government at the moment, that was introduced, I think, a year or two ago, is actually a capital grant. So it's an earmarked grant. It is not a grant that a local government can use for another purpose. The fourth aspect that I will deal with is to do with the budgeting. All local governments in Zimbabwe, regardless of size, have the powers to plan, budget, and expend their money. However, there is one challenge in terms of, I will not say this is an interpretation of the law, but I think it has to be with regards to the culture of governance. For instance, budgets are sent to the local government minister for his or her own information. That's what the provision says in the Urban Councils Act. Yet we have persistently seen that over time, successive local government ministers confuses this as seeking approval of the budget by a local government. So what we have seen is that budgets have been delayed in terms of their implementation because they have not been approved in courts, which means that local authorities can actually go into a new year 3, 4, or 5 months using rates that are no longer cost effective, that are actually carried over from the previous budget. From time to time, we also see that the national government also uses circulars to influence expenditure patterns. For instance, the 30% service delivery to employment cost ratio. This is an attempt by the national government to try to influence in terms of the budgeting process of local governments. The fifth item that I would look at is to do with the decision making. We know that in terms of decision making at council level, there are full council meetings and committee meetings, whereby local governments can make decisions and resolutions regarding the functions that they perform. I will deal with the functions, I think, last. So council resolutions, however, are subject to be set aside by the local government minister. That's section 314 of the Urban Councils Act. So the minister has powers to rescind, either rescind or suspend the regulation, or the resolution. So these resolutions are subject to being analyzed and weighed to see whether they are in the public interest or not by the local government minister. However, then to say who has public interest is something that is up for, or that is very much debatable. And again, the national government, through circulars and directives, can give guidance on matters of policy in as far as what a local government can do or cannot do. The other aspect that is actually crucial, again, is to do with the human resources in a local government. Regardless of size, whether urban or rural, all local governments have the power to recruit, they can remunerate, and they can discharge staff. They remunerate based on the money that they raise. However, there's a limitation to this. As town clerks or chief executive officers in the form of rural local authorities, heads of departments and their deputies, their employment, discharge, and conditions of service are determined by what is called the local government board, which is appointed by the local government minister. I think this since 1995, when the Urban Councils Act was amended, this has actually been very much problematic, but it didn't start in 1995. Around 1986, there were also amendments to the Urban Councils Act, whereby the appointment of senior officials was subject to approval then of the local government minister. So this is something that has caused, I think, a lot of tension between local governments and national governments for some time. We are yet to see whether in the new constitution, when it is being operationalized in some pieces of legislation, whether this will continue or not. But it is likely that this is likely to continue. The last aspect that I will talk about is with regards to the functions that local governments can perform. There are two main forms of functions that they perform, which are called mandatory and permissive functions. Mandatory, these are actually stipulated by law. It is a must that they have to perform. Permissive functions are those functions that they are allowed to perform. For instance, social service delivery by the national government. If you look at urban local authorities, in one of the schedules of the Urban Councils Act, they perform more than 51 functions, and these range from development planning, regulation, bylaws, service delivery, financial management, amongst others. And rural district councils, in their own, they perform 61 functions. And it is also important to say that these widespread functions, I think, in my view, they also account why our local authorities, they perform a lot of, they generate a lot of revenue, because they can raise, they have alternatives of raising money for the local authorities. However, these functions are subject to reassignment and redefinition by the national government. At any point, the national government can reassign the function to any national government entity or not. Historically, we know that this has happened several times. In 1986, between 1980 and 1986, local governments, in particular, Harare, Bulawayo, I think, and Mutare also, they were responsible for electricity provision in their urban centers, and with the formation of ZESA, this function was taken away. And before that, local authorities were in terms of their total revenues, 23% of it was actually from electricity, which means they lost the 23%. And we also know that education was one function that over time has actually transitioned from national government to local government, up to a point when now the situation is that national government is responsible for the teaching curricula and also the payment of teachers, while the local governments are responsible for school infrastructure. And health is also one of the functions. So before independence, 100%, 50% of the budget for city health was actually provided by the national government. 1981, 1982, government actually doubled that to 100%. But from there onwards, the national government could not fund city health. So what we see in most local authorities is that even up to date, the health account is always a deficit-making account for local authorities, because it is a delegated function, but it is not funded with sufficient financial resources. If we look at the latest information, we realize that from 2012 to 2018, the city of Harare is actually making a deficit of $24 million annually for the provision of health services, while the city of Bulawayo makes an annual deficit of around $16 million. Masvingo is still the same, though the amount is around $1 million. So what does this, why is this important? This is important in terms of some of the functions that we are given. To say, you would think that at a layman's term, to say the city might be has autonomy to run its clinics, but without the sufficient resources, it is actually a financial burden in as far as the city is concerned. We also know that vehicle licensing is something that local authorities have been performing. Historically, the city of Harare started collecting vehicle licenses in 1916 up to 2010, when the national government took over the function and reassigned it to another national government entity called Zimbabwe National Road Administration, ZINARA. And lastly, water and sanitation is one of the most important function that local authorities have traditionally performed, and also in line with the Urban Councils Act. But at some point between 2005 and 2009, this function was also taken away from local authorities and given to a national government entity called the Zimbabwe National Water Authority. And at that time in 2005, if we look again at the budgets of most urban local authorities, we realize that 71% of the revenue was...
Sorry, Dr. Mchadenyika, to cut you. May you kindly wind up? Your time is almost up.
Okay, I have actually finished my presentation. That's fine. Thanks.
Okay, many thanks, Dr. Mchadenyika, for quite a detailed presentation, also giving us some insights on the situation in East Africa and West Africa. For now, I now invite the presenters, the speakers, to speak to each other, whether you have any questions about the presentations made by fellow presenter, or whether there are some additional points that you might need to highlight. So I start with Professor Chigwata.
Thank you. I think just to Devson, I think just one part. I think you when you spoke about the issue of the budget, I think on the approval process relating to the budget, where I think the current practice is that there is, I think, the belief in the sector that all budgets must be sent to the minister for approval. And you said, I think that's a misinterpretation of the law because the budgets are supposed to be sent for easy information. So you're quite right. I agree with you that that's supposed to be the case. The only aspect I think added, what I would just want to add to that is the issue of the fact that the increment of rates in high density suburb. So it's something that has always been there in the colonial era, where for all in areas where the black people resided, the increment rates were supposed to be approved by the national government. So that is the only small component that, in terms of the current law, the minister is supposed to have a look at it and maybe give the go ahead on that aspects of the budget, just relating to the increment of rates in high density areas. But I just wanted to get your views more on the role of the local government board. It has been recently constituted. In your view, what would you say, is this in line with the right of local authorities to govern in terms of Section 276? What's your view on that? Thank you.
Should I go gift or?
Yes, Dr. Mchadenyika, over to you.
Okay, thanks. For sure, in terms of the budget, the high density areas, I think before independence they were called local government areas. Yes, that provision is still there to say the national government still has to make sure that any increases in terms of property rates, they have to be approved by the minister. I don't know whether this is still serving the purpose, or in time that needs to be changed. I'm not too sure on that regard. The role of the local government board, I think the local government board is really a necessary entity. However, it is necessary based not on the functions it is performing today. I would suggest that the local government entity, it needs to be redefined in terms of its function. It has to focus on capacity building of local authorities in different areas. Perhaps one like human resources training and focusing on other things again. We also know that we have the Urban Development Corporation that is responsible for capacity building in some areas. So what I would refocus the local government board in the modern world is to really focus it as a capacity building arm of local authorities, urban and rural, but situated at the national government level. That's one thing that I would actually try to focus on. The second thing is that we now have devolution funds that come from the national government. And I'm not too sure whether there is someone in the Ministry of Local Government or some entity that is tasked to make sure to track the funds, to make sure that they're used to the letter and spirit. So perhaps this might be something that one might need to look at to say, can we add more functions based on the devolution architecture to the local government board? But again, I don't think at its the functions that it is performing now, I don't think they are 21st century functions. Local authorities should be able to decide who manage the affairs of their city on their own. That's what I think. Thanks.
Many thanks, Dr. Mchadenyika. Honorable Dube, any additional inputs? If not, we can then move to the audience for the Q&A. Honorable Dube.
Sorry, I did not hear what you're saying.
I was saying, do you have any additional inputs that you would want to make just briefly before we move on to the audience?
No, not now.
Okay, many thanks. So at this juncture, we now move to Q&A to the audience. If you have any questions to the presenters, you can kindly pose to the specific presenter. And Honorable Dube, I also see there are some questions for you in the chat box. You can also as well respond to the questions as the discussion commences. So I now open the floor to any questions from the audience. Any specific question to the presenters, to the three presenters? Yes, I can see Professor Aneo. You can go ahead.
Thank you very much, Gift. I'm going to show face just quickly, just to give a little bit of a more personal feel to what we are doing here this morning. I can perhaps also ask the presenters, when you are presenting and not minding putting on your cameras, you can do as much. I would like to thank all of the presenters so far. For me, who is certainly not any expert at all in local government in Zimbabwe, it's interesting and also scary, really, to hear the resemblances and the areas of overlap. To hear that much of the frustration and challenges with local government autonomy that we experience in South Africa are similar to that experienced in Zimbabwe, even though contexts are quite different in terms of history, etc. The one thing that I would like to get your inputs on, I've heard more than one of you referring to the issue of land, space, spatial planning as an area where we see local government autonomy being threatened, and we all know and understand that that can have a severe impact on what I referred to earlier as the freedom of local government to govern, as so much happens in space and on land and depends on how land is being planned. And the second then was finances and financial autonomy as a prerequisite really for local government autonomy in the true sense. But are there any other areas that perhaps we are overlooking?
Sorry, Prof. Aneo, I think there are some echoes. There are some echoes from your end.
Can I just perhaps get confirmation from Bernal-Lee if everyone experiences that?
Yeah. Maybe it might be from my end. Yeah.
Now I can hear you loud and clear.
Thank you, Bernal-Lee. So, Gift, it seems as if it's on your side, but I am wrapping up my question, and I would like for all three of the presenters perhaps just briefly give us a sense whether or not you think there are other areas, very specific sectors where we see local government autonomy being threatened in the Zimbabwean context. Thank you very much.
So who will go first? Professor Chigwat, do you want to go first?
Hi, I was hoping that you would give David the chance to speak about the Davison, the land, speak about the land because he's an expert in that area.
Okay, yeah, that's fine. So Davison, you can go ahead.
Okay, thanks. I think in terms of land, we have a very serious challenge because we have the major urban land reforms that took place from 2000 onwards. So what happened before that, what happened was that the national government would actually acquire land, the Minister of Lands, and pass the land to the Minister of Local Government. The Minister of Local Government would issue what is called a deed of grant to a local authority or a local government. Then it becomes council land. But after 2000, that ceased to exist. So the situation that we have is that in most urban areas, the vacant land or the undeveloped land that is there is actually state land, urban state land. and that is being allocated by the national government. So in terms of the progress and the development and the growth of the city, in my view, it is no longer in the hands of city councils in Zimbabwe. It is actually in the hands of the national government, because it is now directly allocating the land to individuals, to cooperatives, and to what? A function that historically and also in the law is the responsibility of the city council. So that is one huge challenge, I think, that we are facing in local authorities. For instance, in Harare between 2000 and 2020, the national government allocated 100,000 stands, 100,000 stands, and these were actually regularized later because when they were allocated and developed, it was not in line with the City of Harare planning regulations. So that tells you to say what is the form of contestation in terms of the space and its development in urban areas is concerned. And again, when you look at some of the major urban areas, they are surrounded by rural local authorities. And these rural local authorities, I think they are managed by the national, by the ruling party, if we can say, the cities by the opposition party. So what happens, what we see is that the boundary between the rural local authorities and the urban local authorities is getting urbanized. But the sad part of it is that development is taking place and the rural local authority is taking the resources, the financial resources that are associated with such development, but services are overburdened to the City of Harare or to urban local authorities. For instance, if you look at a granary in Harare, granary is under Zimbabwe District Council, but it enjoys the services of Harare, which essentially it might be defined as a loss to the City of Harare. So in terms of land and the contestations upon it, I think it's one of the major challenges that our local authorities are facing at hand. That's what I would say, Gift.
Okay, many thanks, Devson. Honorable Dube, do you have any response to the question?
No direct response, except to indicate that the main challenge that we have in terms of the land acquisition is the undefined role of the Minister of State for Provincial Affairs, because they seem to be very much involved, which has resulted in a lot of looting and serious prejudices to local authorities as a result. And also, I'm sure from my presentation, you can also understand that issue that related to the 10% commonage that they claim for any settlement development or any housing settlement development that happens. They claim what they call commonage of 10% of the value of the properties that would have been handed over to the local authority for purposes of urban settlement.
Okay, many thanks. I recognize Bruce. Yeah, Bruce is a hand up. Can you kindly go ahead with asking your question?
Okay, thank you. You forgive me, Makadi Madzikoma. I'm also from Zim. I apologize for being very late. I had to attend to some admin stuff, but I might have missed if this was in the presentation. So I just read in the news, I think between yesterday and today, that there's this individual, his name is Philippe Chanwa, to those who might not know him. He's probably related to the former President Robert Mugabe, if I'm not mistaken, but he's been one of the land barons, right? The list that was posted between yesterday and today of the lands he owns, one could almost say that he owns a mini city in Zimbabwe by himself as an individual, right? And my question is, perhaps in two parts, is it really political or it's beyond politics? And I ask this because me being a Zimbabwean national, I'm stationed here in South Africa. I've been here for the last 10 years or so. Is there hope for me? I mean, for local governance in Zimbabwe, if I want land, for example, what hope is there for me when situations like these happen, right? And I ask as well with the thinking that for local government, social institutions work at their best when they serve the normal individual, when they serve the person, right? So if I cannot, get any tangible benefit from it, what are we doing exactly? Thank you.
Okay, many thanks. Who would want to take this? Honorable Dube or Devson?
I indicated to the panel before, Doc Monzora, and said actually the local government system in Zimbabwe is the stuff and substance that nightmares are made of. I can tell you that before you myself here, I also am a victim of having purchased some land here in Gweru, in the city where I represent as an MP. And I'm also on the list of people who were cheated by one of the land developers for having been sold land that was non-existent and that was also double allocated. So I can confirm to you that unless serious political and legal reforms are done, indeed, the local government system and the methods and mechanisms of land acquisition are indeed a nightmare. I will not want to hide that from anyone.
Many thanks for that explanation. I recognize Stephen Beresford's hand is up. Can you kindly go ahead to pose your question?
Thanks very much, Chair. This is Stephen Beresford from Cape Town. I'm interested in it's a bit of a follow-on question, but as Anel pointed out, the people have raised both the question of municipal finance and financial sustainability, and then land and planning and the development of land. And I suppose in the sort of traditional, conventional local government model, the local government plans and manages the development of land in order to create value in that land, which it then can tax through a system of property rates, and then generate that. I think it was Davison was talking about that, that property rates revenue, which is its own revenue. It's generated it itself, and that makes for a virtuous cycle of local government, which makes it feasible for local government to become more autonomous, because it has control over the planning, it has control over land development, it uses that to raise revenue, and it can use that revenue to improve its capacity to enhance the environment and the value of land, and so you get a cycle of sustainability. And then you have an entity that is capable of exercising autonomy. But listening to the other speakers, it seems that many of the many of the levers that municipalities traditionally have to improve, to manage the urban area well, have been taken away and have been removed as local functions. So it strikes me that there's some quite clearly identifiable planks in the structure of local government that are missing, that the speakers have covered. And it's rebuilding the system by rethinking what those planks are to rebuild the house of local government is important before we can look at autonomy, or we have to look at a completely different model for local government. And I'd be interested to know what the speakers' views are on whether that is the point at which Zimbabwe is at, which is thinking through a new model for local government that sort of moves away from that very conventional model of sustainable local government. Thanks.
Okay, thanks for the question. I will quickly go to Professor Chigwata. Over to you, Prof.
Thank you. What I can just say to Stephen, just in a quick response to Stephen, is that so the Zimbabwean system of local government was inherited from the colonial government. There were amendments here and there, 1980, 1986, and here and there, but the system was inherited. Now, if you say the system was inherited, it means it was meant to serve a particular purpose. So it was meant to serve a particular race in urban areas, and in rural areas, it was defined to serve the black population. So when Zimbabwe got independence in 1980, that system was inherited with few amendments. So that's the system that has existed up to, I think, 2013, we had the new constitution. It's still the system that is in place now because it has not been reformed in line with the constitution. So you understand why, in terms of the current laws, the ministers got extensive powers, because those powers were necessary in a colonial environment where everything had to be approved by the national government. Budgets, increment of rates is what Davison has already mentioned. Bylaws are approved by the national government. The national government can come and reverse policies adopted by the council resolutions. So many other areas you could see they are subjected to national approval. So, but that was the system that was there because it worked for that purpose during that time. But when we got independent, we didn't reform the system sooner enough. In fact, if you look at the system, it relies on the ability of the incumbent minister or the existing government to exercise restraint. Otherwise, the minister can actually essentially get involved on almost everything to the extent that it becomes micromanagement of local government. So the new constitution has given us I think the first step. It gave us the first step to say, here's a new framework for local government. Now define the institutions, define laws and policies in line with this framework. Unfortunately, we have not yet taken advantage of the new constitution to do all the necessary process of reform. What we've tried to do is to carry on with the culture that we had used to, a local government system that is dependent on the national government to survive. Just my last point on, I think, what Prof. Anel had mentioned earlier on other significant challenges to local autonomy would be the economy itself. Currently, the economy is not in sound shape. Local authorities are struggling because of the parallel current system where there's a use of US dollar and the Zimbabwean dollar at the same time. And there's always preference for people to pay for services using the Zimbabwean dollar, and it makes it difficult for local authorities and municipalities to go and purchase services. So I think that's, for me, perhaps besides all other issues that we discussed, a major, I think, detriment to the issue of local autonomy, because if you don't have money that buys, I think you can only, local autonomy becomes, I think, valueless in my view. Thank you.
Okay, many thanks for that elaboration. We have several questions here in the chat box. One is from Kwashirai. Kwashirai asks, what I pick from presentations is that while the move to local autonomy is maybe the best for development, it remains in the margins up until there is willingness from political actors with muscles. I think, Davison, can you attempt this?
Yes, thanks. It is important to mention, I think, from the outset that for local autonomy to actually exist, both in the law and in practice, political will is something that is very important. At the same time, like I indicated before, to say that we have different tiers of government, it is also important that for local autonomy again to survive, there has to be cooperation and coordination with other different layers of government. However, the challenge that we have, I think, for us is largely to do with the political construction of the local government itself. To say that it is across political lines, and we haven't managed, our politicians haven't managed to to find a formula or a working formula to allow a different tier of government to actually thrive and to support it, despite it being actually managed by an opposing party or a different party. That said, if we are to change the configuration of political parties today, the local government challenges that we have will still persist, which means that we need to go beyond politics as a construct to understand the local government dynamics in Zimbabwe. Let me briefly qualify this. If we make sure that local governments are managed actually by the same party, that is at the national government level, we still have a challenge with regards to the financing at the city level or at local government level. Up until when health services are provided on a cost recovery basis, up until healthcare services are actually subsidized by the government, the city of Harare will still make a loss of $24 million annually. And city of Bulawayo will still make a loss of $16 million annually to open its clinics. That's the first thing. The second thing is that the human resources part of the city of Harare is around 10,000. 10,000. Now it's around 8,000, but the establishment is around 13,000. But when you look at that staff, you realize that much of the staff, they might not have the necessary skills in as far as where they're actually working from. That's number one. Number two is also to say that more than half, about 52% of all the urban local authorities in terms of their revenue goes to pay salaries and wages, which in itself means that service delivery is then squashed on the remainder. So it means that our local authorities are actually heavy in terms of on the employment side. They need to be rationalized. So there are deep-seated structural issues that we have in as far as our local authorities is concerned. So even if we sort out the politics, that does not mean that our challenges, I think those structural issues are addressed. That's what I would say, Gift.
Okay, many thanks. So we also have another question from Nicolene. Nicolene asks, could you perhaps elaborate on what happens if a local government authority does not have the necessary capacity to perform the delegated functions such as health? To what extent can national or provincial government assist municipalities or local authorities without taking away their autonomy? I will pose this question to Honorable Brian Dube.
Quite hear you. What was the question like?
Okay, let me repeat the question. Yes. Could you perhaps elaborate on what happens if a local government authority does not have the necessary capacity to perform the delegated functions such as health? To what extent can national or provincial government assist municipalities or local authorities without taking away their autonomy?
Actually, the responsibility for health is with central government. What local authorities will be doing is to just complement the government efforts, wherein government must actually be paying, like what they do even with mission schools, paying for the health staff and actually providing for essential medicines there. So it's not like chipping in. It is the primary responsibility of the central government, and local authorities will just be assisting in that regard by creating structures like building clinics and stuff. So what then must happen is government must give resources and allow that complementary role to happen, where the structure and possibly general management of the clinic is with the local authority, but government has the primary responsibility to be funding for that, because ordinarily they are the ones who are supposed to be building all clinics, hospitals, and schools in the country.
Okay, many thanks. There is also another question from Johandri, which says, she says, through some of the presentations, I had mentioned to corruption being one of the challenges for local government. I also heard that Zimbabwean law provide for some measures to maintain oversight over local government and to address suspicions of corruption. But what are the safeguards to prevent oversight measures to be abused for the benefit of political agendas. Anyone between Devson or Professor Chigwata? Anyone would want to take this?
Okay, let me attempt to take this one, or Devson can add. In my view, I think this is where one of the perhaps weakest aspects of the Zimbabwean local government system exists today. The absence of oversight mechanisms to reduce the abuse of supervision, supervisory powers. So in as far as I can pick explicitly, in the 2013 Constitution, the only oversight mechanism that exists currently is the role of the independent tribunal that is responsible for actually dismissing councillors. Previously, the minister responsible for local government was responsible for suspending and dismissing, but the new Constitution has come up with this safeguard or oversight mechanism to ensure that that role is exercised by independent tribunal, and it actually lists a couple of grounds where upon which a councillor can be suspended and dismissed from office. But all other aspects of a supervision, they are exercised subject to very little oversight mechanisms. In other words, as I mentioned earlier on, the minister can resign the council resolution. He doesn't have to report to anyone besides the general route of reporting to Parliament as a member of the executive. He can, even on the issue of the budget, even on the issue of the suspension of the councillors, which has been brought about by the 26th Amendment, he can do that without having to account to another body, in contrast to the, for example, the South African system where, in terms of Section 139 of the Constitution, there is a role for the National Council of Province, there is a role for the Provincial Legislature, there is a role for the National Minister responsible for cooperative governance. So in my view, this is, I think, one of the areas where I think we could, it's a potential area for reform to provide, I think, those oversight mechanisms to reduce the scope for politically motivated interventions in local government or forms of supervision in local government. Thank you.
Devson, would you be interested in adding your voice?
Yes, I can add 2 points to what Tinashe has highlighted. I think there are also 2 more safeguards. One is that there are always audits that are carried out on an annual basis by the Office of Auditor General. They always audit all the local authorities in the country, and also the local authorities themselves. They also engage independent auditors to give their audit opinion. Though I would be quick to say that the reports of the Office of the Auditor General, I think they've been really candid. But again, we didn't see some, not necessarily remedial mechanism. We didn't see some punitive actions to say if a local authority misappropriated resources, be it land or finances. We didn't see the consequences coming. We just saw the reports are very nice, but there were no consequences. Secondly, there is what is called a commission. A commission I think a commission can only be appointed by the president to deal with to investigate a local authority and make recommendations. We saw that the first time one commission actually, which was very powerful, I think was in 1999. In the city of Harare, chaired by Thompson, whereby they investigated the state of affairs in the city. They unearthed massive corruption. That was the first time that the executive mayor and the entire council was fired in 1999 by then Minister of Local Government, John Langagombe. By then, this was a ZANU-PF fired council in 1999. So this then buttresses my point that I mentioned earlier on, to say that we need to be able to extricate ourselves from this political lenses of saying our challenges are largely due to political. And then the entire council was actually fired. The Minister of Local Government, I think, also from time to time, we have seen a number of investigation teams actually being commissioned to try to find out what's happening to the local authority. However, since we are largely politically divided and the lens of analysis is always political, people always tend to look with not necessarily on the facts in the report as they are presented.
Sorry,
but they
Dr.
then tend to look
Mjadenyika,
at,
sorry to cut you. We are running short of time, so I have to cut you. My apologies there. So I would like to thank everyone for participating in this first session on the Zimbabwean case study. And I would also like to thank our presenters, Dr. Devson Mchadenyika, Professor Chigwata, and Honorable Brian Dube. Unfortunately, Dr. Gordon Moyo had to face some connectivity challenges and was not able to be part of this quite interesting discussion. So I would also like to thank all the participants who took time out from their busy schedules to be part of us. So we are now going to take a comfort break and to resume at 12 o'clock. So we also encourage all those who were participating, presenters, and even the audience to join us at 12. I see Professor Aneo, your hand is up. Professor Aneo.
Sorry, Gift, I had a quick question, but we ran out of time and we also interrupted the presenter there. So I will return with my question in the next session, but I would like to ask if at all possible that our colleagues that have presented on Zim stay on, as I think there's quite a bit to also discuss once we've heard the South African context. And thank you also from my side, and we see and hear each other at 12.
Okay, that's fine. Thank you. So we'll meet again at 12.
Welcome back to session 2. We are dealing now with local government autonomy in South Africa. I trust you had, it was a very short break, but I trust it did you good. So my name is Nonhlanhla Ngcobo. I am a PhD researcher with the South African Research Chair in Cities, Law and Environmental Sustainability. Now looking into the South African local government autonomy, I have on my side 4 speakers. I would just kindly like to check, as I'm not sure if Mr. Dr. Danai Masia is with us. If he is with us, if he can just kindly alert me. If not, then I will proceed to introduce the speakers that we have, which is Professor Stephen Friedman. I have Professor Oliver Fuhr, and I have Mr. Stephen Beresford. Dr. Danai, are you available? Are you with us this morning, or is it afternoon already? Yes. Dr. Danai? Okay, then I take it, Ms. Bernally, if you can just kindly confirm, I take it that we do not have Dr. Danai Masia with us this afternoon.
Nonhlanhla, just to alert you that Prof. Stephen Friedman is our first speaker and he is present.
Yes, I'm fully aware of that. I just want to rather introduce all of my speakers. So I just needed to know if he's present or not. But then if he's not present, what I will do is that I will just quickly run through the profiles of all of the speakers. Thereafter, I will then allow them to then go through their presentations one by one. So the first speaker, as Prof, you've indicated, we have Professor Stephen Friedman. He's a research professor at the Faculty of Humanities in the University of Johannesburg. He's a political scientist, a scientist who specializes in the study of democracy. He's researched and wrote on the transition to democracy and on the relationship between democracy, inequality, and economic growth. He has also stressed the role of citizen role in strengthening democracy and promoting equality. He is also the author of Building Tomorrow Today, which is a study of the trade union movement and its implication on democracy, and the editor of The Long Journey and the Small Miracle that he co-edited with Doreen Atkinson, which he presented, which presents rather on the South African transition as well. His study on South Africa's radical thought, race, class, power, Harold Warp and Radical Critique of Apartheid was published in 2015. He's also published on democratic theory, power in action, democracy, citizenship, and social justice, which was also published in 2009. He also writes regularly for The New Frame and has written for numerous journal articles and written also numerous book chapters. Followed by him would be Professor Oliver Fuhr, who is an associate professor at the Faculty of Law, Northwest University. He's obtained his degrees, his LLB at the University of Bewa in Cameroon in 2009 and 2014. He respectively obtained his master's degree as well as his PhD from the Northwest University. He was a postdoctoral fellow at the Northwest University in 2014 and a senior lecturer for some time in the University of Free State in 2015. He's a recipient of many scholarships that have seen him travel the world to faculties of laws in Germany and in Gießen in 2013. He has also published extensively, both in national and international journals, and he's also attended national and international conferences. Currently, he's a reviewer of several law journals and the assistant editor of the BER, Potchefstroom Electronic Law Journal. His research primarily focuses on the role of government in advancing the constitutional ideals of social justice in South Africa. The last person to speak, or not the least though, is Mr. Stephen Beresford, who is an associate director of Pegasus. He's responsible for the group's cities and urban development practice. Mr. Beresford has over 27 years of experience in urban development with a specific focus on urban legal reform. He's also worked extensively with government as a consultant. He's also worked across the continent, particularly in Zambia, Rwanda, Kenya, Zimbabwe, Eswatini, Lesotho, and Uganda. He's also an experienced team leader, and he specializes in leading multidisciplinary and national teams in African countries. His role as a thought leader in urban legal reform in South Africa has been recognized through his honorary appointment at 3 of South African universities. So before he established his own consultancy firm in 2000, he worked for the town planning department in the city of Cape Town and Johannesburg. And he's also worked for the Department of Land Affairs. He's also received the Dubai Award for practice in built environment in South Africa, and his work on reforming urban law in Africa, a practice guide. Stephen holds a postgraduate degrees in law and urban planning from the University of Cape Town and a master's in land economy from the University of Cambridge. Now to my speakers, starting with Professor Stephen Friedman, we are asking today, seeing that South Africa just has this very, one would argue, beautiful, a sound constitution, are we seeing practice or are we seeing theory meeting the law? Over to you, Professor Stephen. Thank you.
Right, I think I'm, sorry, am I now visible? Yes. Am I audible and visible?
You are both audible and visible, Prof.
That's, I can't ask for more. Thank you for the introduction, Chair. You will have gathered from the CV, which is read out, that I'm a card-carrying non-lawyer. So if you're expecting any legal insights, you've come to the wrong place. I'm a student of politics and a student of democracy. And it's from that perspective that I want to offer a somewhat different perspective on these issues to the one which I think is common to many of the presentations. And that is that, at the risk of shocking everybody who's in attendance, I'm not particularly concerned about the autonomy of local government. I am very concerned about the autonomy of local citizens, which is not quite the same thing. So I am less concerned about what local governments can or cannot do than whether what they do enables people in local areas to exercise real control over their lives and over their urban environment. It's from that perspective that I think we need to look at South African local government. And if we look at South African local government, the chair asked for divergences between theory and practice. I think South African local government is shot through with divergences between practice and theory. And in fact, most of what I want to say is to make the point that I think that South African local government is a classic example of how we should move beyond abstract reasoning. And by abstract reasoning, I mean that we assume that because various textbooks or because various legal texts tell us that people have greater power or that people have greater say over their own lives, we assume that they do. The reality in South African local government is rather different. Now, if you look at South African local government, you would assume that the preconditions for local citizen autonomy do in fact exist. South African local governments do have a constitutional role. They are elected. They do have local powers. They even have, which is a topical debate in South Africa at the moment, the electoral system, which most South African pundits seem to like, which is, of course, a mixture of constituency representation through wards and proportional representation, rather than our provincial and national legislatures, which are elected purely on a proportional basis. But if one has a look at the evidence, one finds that local government is by far the sphere of government which the majority of citizens are most angry about and are most contemptuous about and are most inclined to point a finger at. Opinions, not only do surveys show that opinions of local government are very low, but in fact, South Africa has, often unnoticed, South Africa has been in an almost 50-year protest cycle in which we've had significant street protests since 1976. Which only let up between 1994 and 1997. And increasingly, both before 1994 and after 1994, a great deal of those protests have been directed at local government, at mayors, at councillors, who are very often subjected to abuse and worse by local citizens. Now, why is this? Why do people have such a low opinion of local government? Well, I think part of it has to do with history, and that also shapes to a certain extent the way politicians feel about local government. It's important to remember that under apartheid before 1994, local government was used in two ways for the majority of the population, and the majority of the population, of course, are Black people. It was used in two ways. First of all, from 1983 to 1994, as a very clear substitute for political rights. So in other words, whereas whites had full political rights, people classified colored and Indian had partial political rights. Black people, by far the majority of the population, were expected to manage only with quite constrained local government. The second reason is that those local governments very often were seen by local residents as agents and implementers of white minority rule rather than as representatives of citizens. And because of that history, local government has always had a reputational issue to deal with. It was balanced to a certain extent by the fact that in the anti-apartheid movement, demands for non-racial democratic local government were voiced at least from 1976, when the Soweto uprising occurred and the Soweto Committee of 10 was formed in order to press for democratic local government. But that doesn't alter the basic reality that among citizens, local government was seen as a form of oppression rather than a form of representation. But that is not local government's only problem, because local government, and I'm generalizing to a certain extent, but I think that the generalization describes a great deal of the reality, because a great deal of what local government does is likely to anger citizens. Local government is in many parts of the country, identified in the public mind very often accurately with corruption, with mismanagement, and with, most of all, a total disregard for the views and the concerns and the interests of local citizens. Two of the words which were mentioned right at the beginning of this conference, this webinar, were good governance and service delivery. I don't use either of those terms because I think they are both deeply anti-democratic. But I think that in our context, service delivery is a particularly anti-democratic concept because it implies that the role of the local citizen is simply to be delivered to by local governments. And that's not the role of the local citizen. In democratic societies, local citizens are supposed to be the employers of local government. And as the employers of local government, they're supposed to be telling local government what it ought to do, not waiting around for it to be delivered to. And if you look at the protests that I've been talking about, they are very often described in the media and by commentators as service delivery protests. when they are really nothing of the sort. They are protests by people who feel justifiably that nobody pays any attention to them. They are protests by people who are trying to be heard. Very often what they're doing is not demanding service delivery, they're demanding to be freed from service delivery. And by that I mean that very often what service delivery means in local areas is that some committee of officials decides that something ought to be done which negatively affects citizens' lives. In one very stark example, to the south of Johannesburg, the service deliverers decided that a great many people in a particular settlement were living in the wrong place, and that they should be moved to make service delivery easier. Now, surprisingly, people don't like to be moved from their homes because some group of officials feels that this is a good idea, and there was sustained conflict in that area as a result of this. Now, why is it, and I think that's we're coming now to the crux of what I want to convey. Why is local government as it is in South Africa in so many places? I'm not saying there are no exceptions, but as I said earlier, we do have to generalize in order to broadly make the point. And I want to suggest that the reason has absolutely nothing to do with the law, and it has nothing to do with the Constitution. What it has to do with is the nature of our political transition and the nature of the direction which our society has taken since 1994. And at the heart of the problem is that what we did in 1994, which we had to do, which was vitally necessary, is that we changed our constitutional and legal system. But what we didn't change in any fundamental way is our economy and our society. And one of the consequences of that is that we're still stuck with what we were stuck with before 1994, which is what is called today economic exclusion. And economic exclusion fundamentally means that however intelligent you might be, and however entrepreneurial you might be, if you're a young person growing up in the townships and shack settlements in which most Black South Africans live, your chances of breaking into the middle class through the formal economy are very, very slim. Only a very small proportion of people are able to get in. And to some people, some entrepreneurial people and some people who hope to rise in the world, if they can't do it through the marketplace, they hope to do it through politics. And local government is the first port of call, in a sense, if one is trying to get into the middle class in that way. So those who are ambitious to some degree, want to get into the middle class and are able to do it through politics, do try to do it through politics. And I often argue, and I've made this point in many different contexts, that if you really want to understand the dynamics of local government in many parts of our country, you have to understand that very starkly for many local councillors, the difference between being a councillor and losing your seat is the difference between being middle class and poor. And that being the case, your calculations and what concerns you in your job is not how do I make life better for the people I represent. It's how do I remain in the middle class. And that very often means behaving in a way in which you are very deferential towards your political superiors, and you tend to see local citizens as an unfortunate inconvenience in the way of your attempt to remain in the middle class. Now, it's not only, this doesn't only have the effect of alienating councillors from local people. Some of my academic colleagues have done, I think, some superb research on dynamics in local government in South Africa, which show the extent to which networks of corruption, you know, there's a lot of discussion in South Africa today about national level corruption, and it is certainly a real problem. But the really deep-rooted corruption networks in South Africa are very often local networks. And they result not only in corruption, but they result in violence. One of the dreadful phenomena we have to deal with in this country is a succession of killings at local level, particularly in a couple of provinces. And very often, from what we can piece together, these killings are caused when local officials get in the way of corruption networks. And they are silenced in order to enable the corrupt networks to continue. So the point I'm making in summary, because I'm almost out of time, is that if we want to understand local government in South Africa, we have to move beyond looking. I'm not saying that there isn't a role for that, but we need to, first of all, look beyond the autonomy of local government and look at the autonomy of local citizens. We have to look beyond what the law says and what the regulations say, and we have to look at the actual pressures on the ground which are causing local government to act in the way it very often does. And if we start doing that, then we start looking at what the potential remedies are. And in a nutshell, I don't think the remedies at the moment are changes in the legal status of local government. What we really have to look at as a matter of urgency is what we do to ensure that local citizens really do enjoy the autonomy I'm talking about, that they're able to hold local power holders to account, that they're able to make their voices heard. Because at the very least, I mean, there's far more to it than I have time to deal with at the moment, but at the very least, we then create a situation where, given what I said earlier about the difference between being middle class and poor, at the very least, we create a situation in which those who wish to remain in the middle class know that serving their fellow citizens is going to be the way to remain in the middle class, because if they don't serve their fellow citizens, then they will be voted out of office and will be held to account in all the constitutional ways which are permitted in this country. So I think I've taken my 15 minutes. I will leave it at that. There's obviously a lot more detail I could fill in, but I think that conveys the broad thrust of what I wanted to say. Thank you.
Thank you very much for that presentation. I'm moving the people, the constitutional democracy. And I'm taking this to Professor Oliver, who is going to be our next speaker. I must state that Dr. Tianai Masia had a family emergency and couldn't join us. Therefore, Professor Oliver, please take to the floor, sir. Thank you.
Thanks, Chair, for the opportunity. Good day, everyone. Thanks very much, Prof. Anel, and your team at CLES for giving me the opportunity to present. And I am going to follow the slides that Ben Ali has just shared. You give me a minute so that I can see how that functions, and then we can take it from there. Okay. In order not to waste time, Ben Ali, can you just continue to share and then I will talk? I see it has disappeared.
No problem. Just give me 2 seconds to upload it again.
Okay. There we go. Thank you. So, ladies and gentlemen, I decided to present on local government's autonomy and the conundrum of constitutional competencies in South Africa focusing on the recent tussle that we had between the city of Tshwane and the Gauteng Department of Health over ambulance services. And as you will come to see, my thoughts have slightly shifted. What I have in mind now is slightly different from what we find in the slides. So I have to tweak here and there. And that is because I have I've written a bit on this area, and I wanted to avoid repetition and to probably bore some of you who have read the relevant work already. Prof. Anel and I wrote an article on this in 2017, which was published by the Commonwealth Journal on Local Governance. I also published an article on this in the same journal in 2015. And then I wrote a book chapter for Routledge, which was published last year on the same issue. So I was trying to look for a new angle, and I think I found it because I really want to get input and then write up an article and hopefully publish it before the end of the year on this. And I think the new angle is the argument I make as to why the city of Tshwane could have proceeded to continue rendering this service even without the approval of the Gauteng provincial government, and how the city was supposed to go about it. Because we know we are obviously bound by the principle of constitutionalism, and the fact that even though you will come to see that local government has very strong autonomy in South Africa, we are constrained by the constitution. They cannot do things that are illegal. So I try to reflect on how the city of Tshwane and other cities can go beyond obstruction, you can call it obstruction, by higher spheres of government. I have decided to structure, or I decided earlier to structure the presentation into 5 parts. I think I will have to add 1 part to address the how question, which I've raised. And I'll basically paint a very brief picture of how local autonomy is entrenched in the Constitution, how it's guaranteed in the Constitution, and then raise the 2 main challenges that we have in terms of the constitutional distribution of powers between the 3 spheres of government, and then remind you of the tussle that we had between the city of Tshwane and the Gauteng Health Department. And then I would look at case law to strengthen my argument as to why the city has competence to provide ambulance services even without the express approval of the province. And then after that, I will talk about how the city could go about it without, if it did not succeed to get approval from the provincial government, and then conclude on how the distribution of powers in the Constitution affects the autonomy of local government, and how lessons that we learn from case law can help enhance that autonomy. Our first 3 speakers. Our first 3 speakers spoke a lot about local government autonomy. Prof. Chigwata talked about the principle, the way it's understood in terms of international soft law. I think there is consensus among scholars as to what that entails, and I don't want to repeat that. But Prof. Anel summed it beautifully when she referred to the fact that local autonomy actually talks about the freedom of local government to be able to govern. So in the Constitution of South Africa, we find that in different ways. We realize from the reading of the Constitution that municipalities are now recognized as a distinct sphere of government, which indicates that they are almost co-equals with other spheres of government. Theoretically, they are supposed to be equal with national and provincial government. And then we also realize that local democracy that Prof. Chigwata talked of is guaranteed in terms of the Constitution, in the sense that those who really run municipal councils are supposed to be democratically elected through free and fair elections, and that they exercise legislative and executive powers through municipal councils, especially in relation to those that are outlined, the functions that are outlined in Schedule 4B and 5B of the Constitution, what some have referred to as the original powers and functions of municipalities. Please give me a minute. Let me ask those in the house here to take down their voices. I hear there's a lot of background noise. So sorry for the interruption. I'm here in Tanzania and working from home. So there are people at home who make noise, and because I cannot speak Kiswahili, it becomes difficult at times to call them to order. So we also noticed that the financial autonomy, the fiscal autonomy that Prof. Chigwata talked of is well catered for in the Constitution. The same applies to the administrative autonomy. Some writers don't want to talk about. They don't prefer that we refer to it as administrative autonomy. They talk of the power to organize local administration, basically the power to hire and fire. That is clearly protected in the Constitution. And then obviously we have a clear constitutional mandate, which is found in Chapter 7 of the Constitution, Section 152, 153, read together with Chapter 2 of the Constitution, which is the Bill of Rights. And then we also realize that the powers and functions of municipalities are strongly protected in the Constitution as required in terms of theory, and these cannot really be changed without an amendment of the Constitution. We require a two-third vote in the National Assembly for us to have any change. And that is very difficult in the current context, except if smaller parties decide to side with the ruling party. And then we also have what we refer to as the incidental powers of municipalities that are protected in terms of Section 156 sub 5 of the Constitution, which really gives municipalities a bit of leeway to go beyond what is expressly provided in terms of Schedule 4B and 5B of the Constitution. And that provision says that municipalities can exercise any power concerning a matter which is reasonably necessary for or incidental to the effective performance of their functions. So even if a function is not a local government function and it is required that municipalities take action in that area to be able to effectively do what is required of them in terms of Schedule 4B and 5B of the Constitution, there is leeway provided in the Constitution. And then you will come to see there is profound implications of the inclusion of the Bill of Rights and the obligation that is imposed on all three spheres of government to adopt legislative and other measures to give effect to the rights, the Bill of Rights, in terms of what local government can do. We've had a number of cases where this has been interpreted and where the courts have affirmed that municipalities can in fact go beyond what is required of them in terms of Schedule 4B and 5B because of the powers derived from the Bill of Rights or the obligations imposed by the Bill of Rights. So we've had a number of cases where the courts have come out very clearly to interpret and to affirm the autonomy of local government in South Africa. There are many of them. Fetro is one, Robertson is another, and there are many other cases that scholars in this area are aware of, even our students are aware of. So in terms of our Constitution, the autonomy of local government is very strong. Municipalities can do anything that they deem necessary, provided their actions are not contrary to the Constitution, provided they are not acting illegally. They have to comply, as you will come to see, with national and provincial legislation only to the extent that such legislation is constitutionally compliant. So national and provincial government can regulate how municipalities exercise their powers and functions. They can put down guidelines, but the guidelines should not be to such an extent that they make it impossible for municipalities to be able to do what is required of them. And then if you look at the distribution of powers in the Constitution, you realize that all three spheres of government exercise concurrent legislative and executive powers and functions. They have concurrent powers in the sense that all of them can regulate the areas that are listed, the functional areas that are listed in Schedule 4 and 5 of the Constitution. You will see that Schedule 4 and 5 of the Constitution, especially Schedule 4, lists the areas where national and provincial government, national, provincial, and local government have competence. 4B talks about areas where municipalities have exclusive legislative and executive powers. Some refer to those as their original powers and functions. And then 5A contains areas where national and provincial government have exclusive legislative powers and functions. But also, national and provincial government can regulate the extent to which municipalities exercise the powers in Schedule 4B. So there is a layer of regulation there. And then in terms of Schedule 5, you realize that 5A are the areas where provinces can legislate, and that will include things like ambulance services, which is in 5A, not 5B as depicted in this slide. And then 5B contains areas where municipalities have competence, but provinces can legislate in order to lay down broad regulatory guidelines. So we have two problems. The first problem is that the powers and functions of the spheres of government are not always clear-cut in terms of the schedules. For instance, if you look at something like health services appears in 4A, which is an area of competence of national and provincial government. And then you have municipal health services in 4B, which is also an area of competence of municipalities. You will come to see that the National Health Act defines very clearly what municipal health services entails. But just by looking at the Constitution, it's not clear what the difference is. And then you will see that ambulance services, which is in Schedule 5A of the Constitution, can also be classified as part of the health services that must be provided in terms of Schedule 4A of the Constitution. And then the second problem which we have is that because higher spheres of government have powers to regulate how municipalities exercise the powers in Schedule 4B and 5B of the Constitution, some regulation can be intrusive in the sense that it makes it difficult for municipalities to be able to exercise their freedom to govern. And we've had instances where the courts have been able to come in to actually declare some of those regulations to be over the board, intrusive and violating the autonomy of municipalities. We've had that in the area of planning law. We've had many cases in that area. We've had that in the area of water, and I think also in the area of planning generally, not only spatial planning. And then we see that due to this blurring of powers and functions and the powers that are given to provinces and the national government to regulate, there is always frequent contestation over the scope of the powers and functions that the different spheres of government enjoy in terms of the Constitution. And a lot of that has been resolved through court cases. So this recently played out in January, for those of you who were following the news, where the license of the city of Tshwane to render emergency medical services expired, and they tried continuing to provide the service while trying to sort out the renewal. And the provincial government was not very cooperative. The Provincial Department of Health was not very cooperative, and they employed a bit of delaying tactics. And on the 4th of March, they had to order the city to stop operations. And because of that, we had 78 ambulances that were grounded for a period of about 2 weeks, completing activity. And those were ambulances that could have really been able to be impactful, provide a very important service in the context of the COVID battle that we have. And the arguments that the provincial department raised were to the effect that the provision of emergency medical services and ambulances is a provincial function, and that they are taking a decision in 2009 to centralize that function in order to be able to improve efficiency and quality. And the veracity of this can be questioned, given the fact that it's common knowledge that a lot of our hospitals, provincial hospitals, have collapsed. A lot of them are unable to provide even basic services So that is something which one can really call to question. And then the department also said that they had concerns about a particular service provider which the city decided to use, and that it was a bit expensive, and that it puts the life of poor people at risk. So the merits of the arguments put forward by the provincial government can be called to question. I think this was really inter-party politics at play, given the fact that the DA currently heads the coalition government in the city of Tshwane. So the interesting part of the presentation is what I seek to address now, to the effect that we know that the problem was eventually resolved, and the city was able to resume operation of its services. But what if the provincial government had refused completely to renew this license? What if authorization was not granted? I argue that based on the string of case law that you see on the slide that is projected, the city has authority in terms of the Constitution, in terms of the Bill of Rights, to be able to provide emergency health services, even without the express consent of the provincial government. And that is evident from what the courts have said in the cases, which we can revisit eventually. But that said, even if the city has a duty in terms of the Bill of Rights to provide emergency health services, we expect that if the province is challenging its right to do so, the city may as well go to court. That is how I see. That's what I see as the answer to the how question. The city may as well go to court and review the refusal of the province to approve its license, to say that is unconstitutional, and then have it reviewed in terms of our administrative law. And I think the courts will not have a problem to rule in favor of the city and any other city where they can show that they have the resources to do so, and that their intention is really to complement what is being done by provincial government, and not really to compete with provincial government. In essence, that is the thrust of my argument, and I think that in the context of the current challenges which health departments face, and also in the context of the COVID-19 pandemic, it makes sense for cities to be given the opportunity to be able to provide that service. And that service, emergency health services, is closely tied to other services which municipalities provide, and one could argue that that is in line with what is envisaged by Section 156 sub 5 of the Constitution in terms of the incidental powers of municipalities. We know that municipalities are responsible for the disposal of the dead, they are responsible for cemeteries, they are responsible for the regulation of funeral parlors, and all that are closely tied to emergency emergency health services. So on the basis of those considerations, and taking into consideration the willingness and resources that the city projects to have, I think the courts would have been able to rule in their favor. Those are my preliminary thoughts for now. I think I can be able to engage with you during the question and answer session, and I think that I'll be able to shed clarity on things that I probably have missed in the course of my discussion. Thanks very much for listening.
Thank you very much, Professor Oliver Fuo, for that presentation. I think what I take really from your presentation is that the whole issue of intergovernmental relation is really key, as much as the Constitution can say much or is clear on what the local government can do and cannot do. With that in mind, may I kindly then move to our last speaker, Mr. Stephen Beresford. Over to you, sir.
Thank you very much, Nhlanhla, and greetings to everybody from Cape Town. I'm afraid there is somebody drilling in my building, and so there might be some background noise. I hope not. let me put up, I'm going to put up some slides. Can everybody see the slides?
I can see the slides on my side.
Okay, great, thanks. I'm going to give a perspective. I think, although I am trained as a lawyer, I'm going to try and look at this question of local government autonomy from what I would call a more pragmatic angle, but which is one which, to be honest, is informed very much by my day job, which is running a consultancy practice working with local government, and the interactions that I have with, particularly with senior municipal officials, and with the ways in which decisions are made inside the bureaucracy or the technocracy of local government in South Africa, primarily in the larger cities, and to reflect then on what that tells us about autonomy, because I think, like Stephen Friedman was saying earlier, I certainly don't fetishize the notion of local government autonomy. I think it's we can see in South Africa that where that has happened, that the driving local government autonomy in a very single-minded way is not the route to serving citizens and to building a more democratic country and a more efficient country and a more prosperous country. And certainly not, or a more fair country. But I want to start off with just to remind ourselves of the sort of the hard underpinnings of the local government system. I mean, as Stephen reminded us, it's fundamentally a political institution, but it is shaped in the way that it acts in society by legal and financial underpinnings. And I think that I suppose the message that I would want to put into this presentation, and which I think is also, I think has some relevance in a country like Zimbabwe that is thinking about how to effect change to a local government system, is to understand very clearly how these legal and financial underpinnings work in relation to each other, because on the one hand, obviously there's the political reality of local government, and the elections in South Africa later this year underscore that. In between elections, there is especially in the large cities of South Africa, there is an enormous set of machines that are making decisions and decisions which affect livelihoods and incomes and opportunities and life opportunities and social advancement opportunities, and these are being carried out on the one hand, certainly with an eye on political support, but also on the legal and financial underpinnings. And if we ignore the legal and the financial underpinnings, we find ourselves then in quite deep water. So I wanted just to compare. You have a municipality that sits in the middle of two things. It has, and Professor Fuhr has gone through some of this in more detail earlier. There's a mandate in the South African Constitution. The objects of local government are set out in section 152. It starts off with democratic and accountable government for local community, provision of services to communities in a sustainable manner, social and economic development, safe and healthy environment, involvement of communities and community organizations in the matters of local government. And the second part, which is that the municipality must strive within its financial and administrative capacity to achieve the object set out above. So that, and then as Professor Fuhr pointed out, there are in Schedules 4 and 5 of the Constitution, and particularly in Parts B of each of those schedules of the Constitution, are the detailed powers and functions of local government as envisaged and as agreed at a particular moment in time in 1996. And that's also another story which I won't cover today, but it's that those schedules are in many ways reflect a moment in time, a political moment in time that doesn't necessarily translate into the 21st century. But I think that's a separate discussion. And so there's a mandate, there's a set of activities that need to be done, a set of outcomes that need to be achieved by this sphere of government within a bigger system of cooperative governance. But the local government in South Africa is constituted differently to provincial and national government. As Stephen also pointed out, it's elected differently. It is not inferior in the sense that it is in many other jurisdictions, but it certainly is dependent on national and provincial government for many resources and opportunities, and certainly for oversight and intervention. The way the South African system is crafted, though, is that provincial and national government are equally dependent, or should be equally dependent, on local government in certain respects, and I'll get to those a bit later. So there are three sources of funding that a municipality has. The first is, and what I want to just really create here, the story I want to tell here is that there are three sources and they're all going down. And so there's the grants which are received, and there's a very thick set of document with many, which sets out each of the grants that are dispersed to local government for many different functions, including there's the equitable share grant, which is a constitutionally determined formula for equitably allocating amounts of money to municipalities, but then there are all sorts of other grants which are also more special purpose. Then there are municipal property rates, which are based on property values and which are drawn from people whose properties exceed a certain value. And then finally, there are the sales of electricity and water. And around the municipal property rates, these are going down. Certainly at the moment, with a few exceptions, in general, the property sector in South Africa is flat and in decline, and also the municipality's ability to bring more properties within the threshold of paying property rates is very difficult. Is very constrained. And then finally, there's a sale of electricity and water. This has traditionally been a big source of revenue. We've had real problems with electricity supply, resulting in load shedding. In many of our large cities, we have severe drought over the last 5 years, very reduced consumption of water. Large users of electricity and water are tending to go off the grid and generate their own power and gather their own water. And climate change is driving all of this. All of this leads to decreased consumption and decreased capacity. So this really, just to show the trend, is, so on the one hand, around the mandate of local government, and I think, and Professor Fuo touched on this too, that there's a series of cases moving through the South African courts up to the apex court, the Constitutional Court, all of which are confirming the rights of citizens, the socioeconomic rights of citizens around housing, land, water, anti-eviction, all sorts of important rights enshrined in our Constitution, almost all of which translate into a concomitant obligation on local government to up its game, to meet those, to recognize and address and meet those rights, the growing body of socioeconomic rights. At the same time, the capacity of local government reflected particularly starkly in the funding, but there's plenty of other evidence around capability, around competence, around corruption, that adds to that. But the high level figure of looking at the money going to local government, it is going down. So you really have a crunch thing of the work that has to be done is going up, and the capacity to do it is going down. So then, I mean, but right now we have a really tight squeeze, and this is where I want to sort of touch on some of the daily challenges that that municipal officials are facing. We have local government elections coming up very soon. The political atmosphere is getting hotter every day as these elections come closer, and there's real pressure from councillors with an eye on re-election for all the reasons that Stephen pointed out, for officials to be innovative. They've got to, how do they get out of that, how do they then start to recognize more people's needs, address their socioeconomic rights within declining resources? Where can they literally, where they can push the envelope, where they can look at new ways of doing things? But at the same time, and this is emerging from the decade of state capture, but before that, a really deep concern from national treasury reflected in national legislation that we need to have very stringent procurement and accounting requirements in local government to avoid and minimize corruption. So at the very time that officials are needing to be under pressure to be innovative, they are also under extraordinary pressure not to contravene the procurement and accounting requirements. And especially in the large cities, and this has followed as something that's emerged from the growth in multi-party local government politics, around coalitions, around cities changing. Professor Fuhr talked about this in relation to Tshwane. The different party leader dominance of metros changing, and the obsession with among the councillors of wanting to show that their municipalities have clean audits, that they are complying with these very stringent procurement rules. And the rules are there obviously for very important reasons, to protect public money, but the capacity of cities to adhere to those rules at the same time responding innovatively and creatively to growing pressures is low, and so there's great difficulty in getting things done. So I really I'm going to run out of time, and if I were to think of what are some of the options that would help create stronger locally relevant decision-making capability. The first, and I think this was something that came up in Davison's discussion on Zimbabwe as well, is around planning. And municipal planning is one of the many areas that the Constitutional Court has consistently asserted the power of local government. It's consistently asserted the power of municipal planning to bind the locational decisions of the private sector, but also of the public sector. Before 2010, national and provincial governments were not constrained by municipal planning. They could locate where they wished. Now that has changed, and I think that this provides a really important bargaining chip in the intergovernmental process, that municipalities can start to incorporate, can build on their municipal planning power as a part of their intergovernmental strength. I think the ability of municipal officials to execute procurement and processes and contract management is really important. We've got to think about ways of doing that more efficiently and raising that capability. The prospect of relaxed procurement or contract management rules is, I think, very slim, and we've got to now up the game, especially in the big cities. And then thirdly, and I think this relates to what Stephen Friedman was also talking about, as politicians are driven by that urgent need to remain in the middle class, I think that recent events have also shown that that's not, certainly in the city of Cape Town, are showing that that's not just something that affects black councillors, it's councillors across the board. Similarly, officials, and again, especially in the large cities, are in incredibly precarious positions because there are so often, because the difficulties of maintaining 100% perfect compliance with procurement and contract management means that they are constantly at the risk of being fired for unauthorized expenditure. So you have your politicians and your officials who both, first of all, are working are overlapping in the work that they actually do too much, but are also both driven by perverse incentives that are not incentives that translate into a better run, more fair, more sustainable community in which people can live and grow and thrive. So those are really just some very quick thoughts from my side to hopefully contribute to the discussion. Thanks.
Thank you very much, Mr. Beresford, for your contribution. It was certainly an interesting talk. I see that our comment section is running wild. But before we attend to the questions by our participants, I must start with the speakers themselves. I would kindly like to open the floor to invite again Professor Friedman and Professor Oliver Fuhr and yourself, Mr. Beresford, to look at each other's presentations, and maybe you do have something you would like to ask of each other, and any more comments from your side. Professor Friedman, we'll start with you.
Sorry, I'm just, here we are. Just on Professor Fuhr's presentation, I mean, it seems to me that, if you're talking about legal autonomy, if on the one hand you say that you think that provincial government is acting from party political motives, but on the other hand you say that you believe that the court would find in favor of the municipality, then you're saying the system works. You're saying that there is legal autonomy because that legal autonomy can be enforced by the courts. I don't think any constitutional system is devised assuming that everybody's going to behave in the way in which the Constitution wants them to. And if you're confident that the Constitution will be enforced by the courts, then it does seem to me that the system's working. I don't think that there's any substantial disagreement between Stephen Beresford and I. I mean, I'm certainly not suggesting that those very real fiscal and other issues that he raises are not crucial. It's just that for me, the question is always, well, does one deal with those issues by some sort of technical tweaking of the system, or does one try to ensure that citizens have a greater voice? Because the issue Stephen is concerned about, I mean, this very valid point he makes about more to be done and less resources to do it with. I think that really affects citizens very directly. To me, the question I would ask in this situation is that how can citizens gain greater control over that process, so that also, sorry, and I don't want to monopolize, also the question of what local government should be doing in Stephen's presentation quite accurately today is what another sphere of government wants it to do. I mean, shouldn't we be talking a bit more about what local citizens want it to do, which I think is rather absent from the conversation. So I think those are the two major comments I had, but I didn't have any particular disagreement with either presentation.
Thank you very much, Professor. Professor Oliver, may I kindly then start with you, and then we'll take it to Mr. Stephen Beresford. Thank you.
Thanks very much, Chair. Thanks. I think that I must confess that I was a very poor listener when my colleagues were presenting, because I had thoughts running through my head, especially since I had not finalized my thoughts before presenting. They kept changing. I've changed my paper about 3 times. But I agree with the comment that Prof. Friedman makes, that the system is in fact working. The system is working, and we know that those tensions are there, and they are inevitable. We are just trying to see if we can reduce those tensions and make sure that where the intergovernmental channels for dispute resolutions don't work, we should be able to fall back to the courts, which have been given the task of acting as arbiter of the Constitution to ensure that we get redress. And luckily, the courts have been prepared to use their wide remedial powers in Section 172 of the Constitution to be able to address a lot of these disputes. We know that there are many in the area of water, for instance. We saw how the courts were able to intervene and indicate that the minister could not really determine the prices of water that Merafong City could impose on a mine in the context of the Water Services Act. In the area of planning, there are many cases, many cases, going back to Maxan, and then the cases in planning, special planning that culminated with Habitat 2. So, in fact, the system is working, despite the political fights that we have, especially when the 2 or 3 spheres of government are not managed by the same political party. And that also links up nicely with the question which Prof. Ane asked as to whether we should be clinging to the traditional conception of autonomy, and whether this is capable of facilitating the type of development which we want, and local democracy in South Africa. I think that generally, most of the scholars that I've read agree with the principles that Prof. Chigwata was able to outline at the very beginning of the presentations today, the principles of local autonomy, and I think that our constitution accommodates those very well. The argument which I make is that the constitutional distribution of powers, the way it is, the interpretation and the implementation thereof, has the potential to constrain local government autonomy, and that is because of the blurring of lines of responsibilities and the often intrusive regulations that we have at the national or provincial level. But despite those 2 difficulties, I think that those principles are well accommodated. We should stick to them. Even the distribution of powers is something which, in terms of best practice, is supposed to be clearly outlined and then protected in such a way that they are not taken away, powers of local government are not taken away arbitrarily by other spheres of government, like in the context of other countries. What we would love to see is that the law should be interpreted purposefully and very generously, the way the courts have done, to the extent that municipalities that really have the resources and the capacity and who are willing to push beyond what is typically outlined in the schedules should be able to do so. The courts should be able to support them to be able to deliver even services that are not typically considered to be municipal services. There is work that was done by the University of Cape Town, University of Western Cape, the center where Chigwata belongs, where they have outlined a number of criteria that we should consider when it comes to the allocation of powers and functions. So to my mind, if most of those criteria are met, including capacity, including resources, there is very little reason why, if a municipality is prepared to assist a province to deliver a certain function, a province should not accept that assistance and look for means of obstructing or thwarting the willingness or ability of a municipality to provide that particular service. So I think the courts have been very supportive, and I think that is the route to go. And the point which I'm making is that where a province or national government refuses to do so, despite the fact that those requirements have been made, municipalities should be free to approach the courts challenge that, and I think that the courts will certainly rule in their favor. So yes, the system is working, Prof. Friedman.
Thank you very much, Professor. Mr. Beresford, over to you, sir.
Thanks, Nhlanhla. I mean, yeah, I got an opportunity by speaking last to reflect on on the other speakers' notes. But two things quickly. First of all, just to Professor Fuhr, I wouldn't overstate the difficulties that come from a municipality and a province being run by different parties. I mean, that can accentuate things, but the DFA judgment that established that sort of set the whole tone for the recalibration of municipal planning powers was when the city of Joburg took the Gauteng province to the Constitutional Court. They're the same political party. Here in the Western Cape, there are numerous examples of really crazy tension between the province and the city. Again, refusing to cooperate on areas that are that sit in various parts of Schedules 4 and 5, purely because of tension, political tension. Two spheres, same party. There have certainly been examples of that in the Eastern Cape as well. So I think that I think that when they're two, and I know in Zimbabwe that when it's two different political parties, it also becomes more. I mean, the conflict becomes sharper, but the conflict is inherent already. It's not something that only comes from that situation. To Professor Friedman's point about I mean, how can citizens influence the ways in which decisions are made at local government? I mean, obviously that's the big question. We do have quite an elaborate system of ward committees, ward councillors, ward mixtures of proportional representation and ward representation. We have tightly prescribed processes of consultation or of publication. I think is probably a better word. Those are very starkly juxtaposed with the ongoing dissatisfaction with local government. And the relatively low levels of participation in those formally created routes for engagement between citizens and the municipality. To my mind, that's a real challenge that is beyond tweaking the system. That's around really rethinking how we deal with community-based power and municipal power, each of which are driven by their own considerations. But certainly on paper, what we have is something that would appear to tick those boxes. In practice, it doesn't. I think, sorry, just to go back to Professor Fuhr's one point about the purpose, the tendency of our courts to adopt a purpose of interpretation to socioeconomic rights is heralded around the world. It's an example for courts all over the world, in developed and developing countries. However, the effect of that is to add pressure in practice on local government, and there's some real questions of to what extent this expanded set of socioeconomic rights is translating into the ability of citizens to realize those rights. So I think there are two ways of looking at the South African court's tendency towards a purposive approach, which is driven by all the right instincts, but has outcomes which are difficult to incorporate into the current mix of legal powers and duties and financial resources and human resources.
Thank you very much, Mr. Beresford. If I'm allowed, in fact, as the chair, I am going to assume just a little bit of power. Please bear with me. I would like to at least invite Professor Tinashe Chigwada. I know that he is based in South Africa. If he has maybe something to add, and Professor Honorable Brian Dube and Davison, just maybe there's something you might want to add into the South African perspective as stated by our panelists right now. And then only after will we move to the Q&A session where I can invite the entire audience to come in. I am sorry to be pushing my powers, but hey, the chair allows me.
Thank you, Chair. If I may start. I think when it comes to the South African case, I think one of the presenters mentioned earlier on that, you know, on the continent, South Africa is often revered for its sound legal and institutional framing for local government. But on the other side, I think if I may say the downside of it, of the 257 municipalities, you actually have quite a substantial number of municipalities that are failing. We have got cases where there is rampant failure, both at local government level and at the provincial government level, to actually effectively carry out supervision of municipalities. I think, for example, in Northwest, you know, significant number of municipalities are under intervention. My question is, what do you do when there is local autonomy entrenched in the constitution and the courts are there to actually promote it? They've shown the appetite to promote it, but there is just rampant abuse of such local autonomy. I mean, the state of financial chaos and administrative chaos in many municipalities. I think, what do you do in such cases? Thank you.
Thank you, Prof. Chigwada. Maybe I can give Professor Oliver the chance to answer this question.
Thanks, Chair. Before I go to that question, I think I want to agree with the 2 points that have been raised by Mr. Beresford. I agree with him that just by looking at the constitutional distribution of power, it is inevitable that conflict is built into conflict is inherent in the manner in which the powers and functions have been listed. And I am aware, and I agree with him, that we've had many groundbreaking judgments that have ended up right at the Constitutional Court, where they emanated in jurisdictions that are controlled by the same party, especially in the area of planning, for instance. Most of them were in the Western Cape. So there he's correct, and I agree with him. And then the other question that the other issue that he raised about the purposeful approach to constitutional interpretation, which is adopted by our courts, adding pressure to municipalities. Yeah, I agree that it adds pressure, but luckily the way our constitution is also framed and the way municipal services are categorized, it does not make it an absolute obligation which one can just walk to the court and say a municipality has failed to provide most of the things that are promised by the constitution, and one gets relief immediately. I think the important point which we should take home, and which I emphasize, is that it really creates scope for municipalities that have the resources to be able to do more. If you have the resources, you do more. Like in the context of the example which I use for the city of Tshwane and the Provincial Department of Health, I don't see any reason, I don't see anything wrong if we have many or more ambulance services that are being run in a city, private, local, provincial. I don't see anything wrong. I think it really enhances the availability of that particular service and ensures that the response time is quicker. So we can disagree on that, but I think we should focus on the positive also that such an approach to interpretation brings. And then in relation to the issue which Prof. Chigwada has raised, I agree with him. We know that there are many municipalities that are struggling. at least 1/3 of the municipalities we have in the country cannot do the basic things that are expected of them. And then we have about 1/3 again, which are in between. They are managing. And then we have only about 1/3 which are doing well. So corruption is a problem. The embezzlement of state funds is a problem. That is something which has to be addressed by law enforcement agencies. The president is talking tough. We expect that the law agencies should be able to do their job and clean up the system a bit. If he's given a second term, we know that there is a significant pushback from other camps that it's a problem which I think our law genuinely attempts to adequately address. For instance, if you look at the Municipal Finance Management Act, if you read it, you read the Constitution, the principles in the Constitution, the principles in the Municipal Finance Management Act, you'll really be surprised to see that we have so much rot, despite the good laws that we have on paper. So I agree with you that we have problems, and those problems have to be addressed. Law enforcement agencies, Chapter 9 institutions, like the Office of the Auditor General, should be doing more to ensure that we can be able to rein in the wasteful expenditure which we incur on a yearly basis. Thanks, Chair.
Thank you very much, Professor. I am going to now open the floor to the participants that we have today. And in doing so, I am going to start with a question from Simon, who asks Professor Stevens that he's rather asking that since we are talking on the autonomy of the citizens themselves, can the professor elaborate on how he thinks that this can be done to ensure that citizens' autonomy is respected within local government? But before you answer that, Prof, may I kindly just recognize the one hand that is coming from Professor Anel. Professor Anel, you had a hand on. Yes, you had your hand up.
Yes, Nonhlanhla. Actually, please let Prof. Stevens respond, and then I will, Prof. Friedman, and then I will latch onto that as I have a related question. Thank you.
Not a problem at all then. Professor Stephen, the question as asked by Simon, please. Thank you.
Yeah, thanks. Just one thing, small thing before I do that, which I should have, it only occurred to me after I'd replied to Professor Four. If you're worried about the kind of issues he's worried about, which is a lot of this discussion this morning about the practical autonomy of local government, I'm surprised that nobody's mentioned this morning the district development model, which the president is very exercised by and national government is very exercised by. And this is important if you have those concerns, because the official line on the district development model is that it's there for other spheres of government to help local government. It obviously raises the question that help, in inverted commas, may also mean tell what to do. And of course, many people would make the argument that because there are, as he's just pointed out, so many dysfunctional municipalities, that them being told what to do is not a bad idea. But of course, those of us who are concerned about citizen control would have a problem with the idea that you can fix local government by having national and provincial tell it what to do. But I think people who are interested in autonomy need to look at this district development model, because it does seem to be the direction government has decided to move in. As far as Simon's question is concerned, look, to me, and Stephen Beresford talked about the formal procedures which exist. I've written a great deal about this, and in a nutshell, I don't believe those formal systems will ever work. I don't think you actually ensure democratic local government by setting up a web of committees. in which people have to participate in a particular way at a particular time, etc. I mean, essentially what we're talking about here is making local democracy possible. And I would start with something which I didn't have time to go into, although I talked a bit about the killings. Something is a very basic constitutional right, which is freedom of association and freedom of expression at the local level. And there isn't nearly enough of this at the moment in townships and shack settlement areas. And what I'm talking about here specifically is that in many areas you have local power holders. You know, their links with it's not a purely political party phenomenon. You have local power holders who do not want their power challenged, and they very often work with the local police to ensure that their power is not challenged. Some people may or may not be aware. The example which is most often discussed is that of the shack dweller movement, mainly in KwaZulu-Natal, Abashlali, Basam, Jondolo, which has been subject to, I mean, the most horrendous activists have been shot dead. The president of Abashlali has had to hide because his shack was destroyed, etc. And it's not just happening to that one organization. It's not just happening in that one area. So I think that there's a whole lot of work to be done on identifying and trying to deal with just basic suppression of people's right to speak. But I think beyond that, it's a question of how we can more effectively make local government something which citizens are part of. My own view on this is that we need to start with the flow of information. We need to look at the way information is made available to citizens. The National Treasury's tried to do some interesting things with that. I have some criticism of that, but I think the first step is far more information. Secondly, as I said earlier, far more opportunities for citizens to react to that information. And then finally, an attitude from local government which accepts that as long as citizens react to you in a constitutional and a legal matter, it's the citizens who get to decide how the conversation should take place and not the local government. So let me leave it at that for now.
Thank you very much, Professor. And then with that, may I kindly then revert back to Professor now, who will be followed by Professor Oliver. I note the hand is up, and I might kindly just add, Marisol, I see your question, I noted. I do think it's very much similar to what Simon asked, and it has been answered. If not, please kindly let me know.
Thank you, Ntantla. Prof. Friedman, I am really delighted that we have you present today. You are a fresh breeze among us lawyers, thinking in black and white lines often. And you are testing our understanding of things. And the one image that comes to mind when listening to you and all of the other presenters really is that when talking about local government autonomy or the freedom to govern, we see a sandwich in where local government or municipalities then find themselves in the middle, with higher levels or higher spheres of government on the one hand, and then the community, the local communities on the other hand. The one question I have in relation to more power to the people and more governing power to the people and understanding citizen autonomy better is what the impact is of a divided society. And I'm asking this as I'm thinking of a recent case in Northwest, you may have heard of this, where the court granted permission to local community members taking over services where the municipality simply could not deliver after repetitive intergovernmental warnings and also earlier court intervention. I'm just worried about representativity and representation, really, where a sector in the local community takes action of that kind. I just wanted to have some of your reflections on whether or not the continued division in our society has an impact on greater autonomy for the people. Thank you.
Yes, thanks for that question, and thanks for the comments. Lawyers don't usually respond to non-lawyers in that way, so thank you. It's a very important question, and you're absolutely, it's hugely important. yes, there are divisions in the society. There are divisions in every society. And that's why we have democracy, quite frankly. If there weren't divisions, we wouldn't need democracy. So if we all felt the same way, we could simply just appoint somebody to go and do the work. And it's for that reason, incidentally, that I have problems about, you know, these participation committees that Stephen Beresford was drawing our attention to, because they don't allow for a proper test of who has support and who doesn't. So it's very important in the light of your question to stress that I'm not suggesting for a moment that we need an alternative to the form of representation we have at the moment. I'm very comfortable with the form of representation we have at the moment. It's a question of how we get that to work. And the way in which we get that to work is to make sure as much as we can, and it's as Steve Beresford said, it's very difficult. I'm not underestimating that. That everybody has a voice, and that hopefully the voice of the majority is the one that's heard, and B, that we find ways in which the minority can live with what the majority have decided. Your concrete example, the one of citizens taking over services, is a very good one, because actually my understanding, when people in this country talk about citizens taking over services, they're talking about some citizens taking over services and making sure that they operate for those citizens, very often ignoring the interests of other citizens. And it doesn't take too much imagination to realize that in our society, the citizens who take over are the affluent citizens, are the citizens who have resources. And that in effect compounds the problem, because you have a situation if that operates the way in which those who push for it wanted to operate, in which the people who are already affluent get decent services and the other people don't get any services at all. So I certainly don't want to suggest that that I'm operating on this model A, where I think everybody has the same interests and the same views, because my understanding is based on just the opposite. And secondly, it's precisely for that reason that the final arbiter of any dispute has to be elected government, because that's the only real test we have of who has majority support. But we need to devote a lot of attention to how to make sure that what elected government does actually reflects what the majority of citizens wanted to do, and B, recognizes that in a democracy, the minority on a particular issue also has rights.
Thank you very much for that.
Thank you, Professor. May I kindly recognize Professor Oliver Fu, whose hand has been up. Thank you, Prof.
Yes, Chair, I just wanted to respond to the concern that was raised by Prof. Friedman in relation to the district development model, just to indicate that CLES did some work for SAGA and were able to indicate to them very clearly that it cannot be rammed down the throat of municipalities. They have to voluntarily get into it, because if they were to be forced to do so, it will violate their autonomy. And the laws, especially procurement laws, for instance, do not currently make provision for the district development model to be able to operate in the manner in which the president markets it. So a lot has to be done. Let me rephrase. It is currently impossible to force a municipality to be part of a district development model. It violates their autonomy as protected in the Constitution. We've made that known to SAGA.
Thank you very much, Prof. I have a question here in my comment session. I noted that some of these questions have been answered, and Prof. Anel's questions, she did ask herself. I have a question from Marisol here, who asks if local government autonomy should be placed or prioritized above good governance, or how do we balance the two concepts at local government level, especially in light of the failing municipalities, or municipalities that have rather been placed under administration. I think this question heavily also ties in with the question by Onkarabile, who then asks, And I know Professor Oliver, you might have a say in this one, where Section 39 can sometimes maybe be or not seen in good light by other people that would actually then argue that Section 139 of the Constitution in itself is an interference in local government. If you can just kindly share with us your thoughts on that. And I will go back to also to Mr. Stephen Beresford, and if he has something to say. After Mr. Stephen Beresford, I do believe that I will myself be out of time.
Thanks, Nomhlanhla. I think Prof. Chikweta touched on the issue of supervision as being an integral part of autonomy in the morning. Local autonomy is not absolute. It is generally agreed that we have to put mechanisms in place to ensure that we supervise higher spheres of government, supervise local spheres of government, and once the procedure for supervising them is clearly outlined in legislation or the Constitution, and that is followed. I think we are fine with that. We are just worried where there is no clear law regulating it, and people are able to do things as they please. So supervision is an integral part of local autonomy. You cannot separate one from the other. And I could say the same thing in relation to good governance and local autonomy. The Constitution provides for local autonomy. The Constitution provides for good governance. Sticking to what the Constitution requires as mandated by the principle of constitutionalism, and even the principle of constitutional supremacy requires that we ensure that both of them are respected, that we adhere to both of them, both autonomy and good financial governance. One does not exclude the other, except people want us to refer to what obtains in other countries where you don't really have democracy, but you have what people could refer to as governments with minimal levels of corruption. But that is not what our Constitution envisages. It envisages that there should be democracy and there should be good governance. They are not exclusionary. We are supposed to find a way of ensuring that both of them work.
Thank you very much, Prof. Mr. Beresford, your last comments, perhaps?
Thanks, Nomhlanhla. Just very quickly, on Prof. Friedman's question about the DDM. Yeah, I think a lot. I don't want to be too skeptical, but there's a bit of a sense of the emperor and his new clothes around the DDM. It's very unclear exactly, certainly to me, what that means as a different model. If I were to be very frank, I think what I've often felt over the years is that Section 139 in fact is an opportunity, and that what we should have are manuals and guidelines and procedures for templates for implementing Section 139. That where the provincial and national government are fulfilling their duties to support and monitor local government, they are immediately positioned to intervene with the Section 139 intervention that is targeted, that's focused, that doesn't take the whole municipality down, but fixes a problem before it gets too big. To my mind, that a transparent procedure like that, with templates and guidelines that understood, might well be a more useful way to frame that intergovernmental discussion. But that's just, and it's more come, I think, out of frustration when we see Section 139 seen as a bogeyman, and then when it is used, it's used in a chaotic way that is generally too late, and very unfortunate. Just to pick up the other Stephen's point about how do citizens. I agree that those committees and processes are not working. Certainly, what's happening in some of the Western Cape and some of the Eastern Cape municipalities. I've sort of lost a bit of touch with Gauteng and the northern provinces over the last 10 years, but has been the emergence of sort of hyper-local parties at a local level that are able to secure a certain number of seats in the municipality, that as we get, in situations where we get very close to hung councils, they are able to play a disproportionate or exert disproportionate influence. Sometimes they represent the affluent, sometimes the poor. But that phenomenon at a local level is a way in which some frustrated communities are able to then play in, and they often don't have the capacity and the clout and the maturity, which I know is a contentious term to use here, but to really manage their kingmaker roles, because they're within a fraught political context. But that is something that is a manifestation of community unhappiness that then gets transferred into the formal system in that particular way. Thanks very much.
Thank you very much, Mr. Beresford. May I kindly at this point state that I myself, as the facilitator of this session, have really learned a lot, and it's both a privilege and an honor for me to have facilitated this. Thank you very much to Professor Stephen Friedman, Professor Oliver Fuhr, and Mr. Stephen Beresford. I'm going to hand the ropes over to, I believe, Professor Anel. Thank you very much.
Thank you very much, Nonhlanhla, and I want to echo, I am really impressed by the level of discussion and the points that have been raised today. I feel inspired, if I can use the word, in the sense that I think we have only started to scratch the surface about an important topic, whether we want to cast it as autonomy or something else. If we want to pull it down to the bare essentials, I think the point is that we see struggling local government both in Zimbabwe and in South Africa, and that as scholars and thinkers we are trying to find the reasons behind it, and we are trying to find solutions. And the discussion today on the autonomy of local government is just a part of it, a small part of it. And I'm glad that we are having this conversation. I don't think that we have covered it all. For example, I think there is a distinction to be made between understanding local autonomy in the urban and in the rural context, and with the involvement of traditional authorities, both in Zimbabwe and South Africa. And that is just one of the issues I think we did not get to. I would like to, I've made quite a few comments during the course of today, both on the Zim panel and then on the South African panel, but I don't think there's any merit in me repeating what has been said. I would like to just use this opportunity to thank the presenters who have joined us from Zimbabwe, even though not all of them were situated in Zimbabwe, and equally on South Africa. You've heard that Oliver is sitting in Tanzania at the moment. I thank you for your time. You've prepared well. You certainly generated discussion and left us with food for thought. I would like you to stay involved in this discussion, be it organized by this chair or by other organizations in South Africa and Zim. I think we, as scholars at least, have a responsibility to help find solutions to the challenges faced by local government in both countries under discussion today. I wish you well. I also want to, just before I say goodbye, thank the participants. Many of you are students, but we've also had participants from other sectors, and I thank you for your time. The two facilitators, Gift and Nonhlanhla, you did an excellent job, and also for Bernally, who managed things in the background, thank you to you as well. I wish you all a good day, and earlier on I referred to a sandwich in a metaphorical way, but now you can rush off hopefully to find that sandwich for lunch. Thank you and goodbye.
Thanks, Anel.